I plead the fifth.
Well, then I'll take your driver's license.
That's right, man.
Huh?
I'm out of here, man.
Okay, how about you do this?
What?
Step off.
You got no business being asking.
Yeah, I do. You can't be driving on the road. Step off now.
I can't drive on the road. I just flew across the street. What are you talking about? I can't drive on the road.
No, you didn't. You were just northbound on Racco. I saw you. You were at the light.
What's wrong?
Okay, I'm not going to ask you again for your driver's license. I'm not going to ask you again.
Or what?
Or I'm going to take you to jail. Shut it off.
I don't have driver's license. I don't have it on.
You have an ID card?
Yeah.
Okay, then let me see your ID card. Where's the key to this thing?
It's right there.
Where?
Anyways, I got a law that says warrants are unlawful anyways.
Okay.
A lot of them, most of them.
Why don't you do me a favor? Why don't you come right here, okay? Because I don't want you right behind me while I'm in my car. Put it on the kickstand.
You know better, I'm not the one to harass. I've been doing about 28 years, so you think I'm the right one now, but
okay.
You get your job took from messing with me. 28 years the law, trust me.
Okay.
Yeah. Remember, you took an oath to uphold the Constitution, don't forget that. Your oath is to the people.
You got a plate or anything on it?
You got no business even be asking these questions. It's already showing your harassment right there. That's how unintelligent you are.
Why don't you just stop? Just knock it off.
Well, you guys are harassing me.
No, just stop.
Whatever, I'm stopping.
Got any paperwork for it?
You ain't got the right to just ask people. It's like me.
Okay.
Do you have your driver's license? You can't just ask that for no reason.
I can.
Don't be under suspicion of a crime.
Do you have it?
There's no crime.
Do you have it?
You don't have reasonable suspicion of probable cause.
You're driving an unregistered motor vehicle. That's our probable cause.
You don't have probable cause.
Okay, all right.
How do you know that? Do you know where's the evidence?
There's no plate on.
Take your backpack off.
No, you can't arrest no one for no purpose. Totally unlawful. You sound
okay.
stupid.
Okay, that's fine. Put your hands behind your back.
Yeah, you don't put your hands behind your back when I arrest you.
Okay.
Yeah. Because you're the one violating the crime now.
Okay.
Sounds stupid. Actually, I got the register card in my.
Well, I already asked you and you refused to give me any information I've asked you for. You want to argue with me about it every time?
Give it. I just said I don't have to.
Okay. You do though. It's a traffic stop. You have to provide
your information. I got it right here in my wallet. Okay. Right here. I got it right here.
You can't drive an unregistered motor vehicle on the roadway.
I got it. It is registered. It's right here. It's right here.
Why wouldn't you just tell me that at the beginning?
You didn't say you're going to get it to. I just said as a question of law. I said I don't need it. That's just a question of law. I have the right to say a question of law.
Okay.
I didn't say it was going to give it to you, did I? Don't lie. If you lie, I'll get you perfect report.
Okay, well, I'm not.
Okay, but it's in there, like I said. It's in there.
Well, you can have a seat in here. Have a seat.
29.
He said he had the registration. Where's it at? Oh, hold on. I'll get you. Hold on. It's a card?
Little white card.
Okay. This one?
No, we got it in our wallet. I think on the left side here. Left side right there. Left side right here.
Where's the plate?
That's not how it's supposed to be displayed, right?
I don't know moped law. Impeding traffic. Am I talking to you?
Well, I'm telling you.
Well, am I talking? Answer my question. Was I talking to you? Okay, sir.
The light was red.
Okay.
All the cars were stopped behind. What the hell are you talking about? You get trapped. It didn't make sense. You ain't got no evidence to support it, so don't even try to lie. It ain't gonna work. You're smart, you guys. You know that by now.
What do you say?
So you can't just say something that's gonna stick. You got me on video impeding no traffic. Stopped at the light like all the rest of the cars, man. We stopped at the light. When it went
Yeah,
green,
but
they
I knew
crossed.
who you
License.
Yes, you do.
No, you don't. I just beat a case in Southgate trying that bullshit. You know what? They talk that shit too.
Okay.
Because let me show you. Let me tell you something. Under federal law, 18 U.S.C. Section 31, subsection 6 and 10, a motor vehicle is defined as one being used to carry passengers and property for profit. You don't have evidence that I'm carrying passenger property for profit. I don't need a license for that. I don't need a license for a car, nothing. You guys mess with me, you're going to violate my constitutional rights to travel and that definition right there, and you're going to have no legal basis. You're going to show you're harassing, commit a crime against me, make yourself civilly liable, lose your job, all that. That's the reality. I've learned all that because I've been in law 28 years.
Yeah, what do you do for law?
That's right. I study criminal and civil.
You practice?
That's right, I practice. I file stuff in court. I just beat tickets for that talking that license shit to South Bay Police. And guess what the prosecutor did? Sit up in court, I moved to dismiss this case after I made the argument that I just told you right now. You guys need to learn the law. I know what the state law says, but you got to learn what the federal law says. But you guys are duty bound to uphold over any bullshit state law that's unconstitutional. What does the federal law say? The statute I just gave you. Look it up right now. 18 U.S.C. 31 subsection 6 and 10 defines a motor vehicle as one only being used for profit. I'm not working for a DoorDash. Therefore, I really don't need registration. I don't need license, insurance, none of it. For a car, motorcycle, none of that.
You do need insurance.
That's true. What did I just say? And the U.S. Supreme Court cases say the same exact thing. You know why? Because we as humans have the human and constitutional right to travel. Meaning we don't need a human's permission. All this license is for driving a motor vehicle. Guess what? But that's only for profit. See, the state law just doesn't say that. Which is why I'm in the process right now of changing that. And it's going to say this. You cops stop using this unconstitutional state law as the basis and think, oh, we're within our lawful limits. No, we're not. And even before I change it, you still can't get off the hook because you know why? Remember, you guys stuck to the oath of the Constitution. So when you violate, you're liable. You know, like that. You ain't got no qualified immunity. When you violate, the court's already said. That's it. You're liable. As long as it's law that's been established, it's called clearly established law, which this is. It's been established for years. The U.S. Supreme Court said this because it's exact word, right to travel. What does that mean? No license is needed for a car or anything else in a motor as long as you're not doing it for profit. Because that's a privilege. You need the license for a privilege, not a right. Just because the state law is in violation right now, that don't give you guys the okay, and you're supposed to ignore it because it's not in complete compliance. It just says, if it's mechanically drawn, it's... No. Then they stop. They don't give the complete definition. Now look in Google right now, 18 USC, you'll see what I'm saying is true. I went down to the Detroit Mercy Law School and made sure that it wasn't just someone typed up on a computer or whatever. No, it's in the law book. It says the same thing. But you can see that from law sites anyway, it ain't from anyone put their definition on it. It's the actual law made by Congress. Article 6 of the U.S. Constitution says what? Federal law, which is that statute I just mentioned to you, 18 U.S.C. made by Congress, and the Constitution of the United States is supreme law of the land, meaning it overrides state law, meaning you must ignore the state law that's in violation. Meaning I'm all within my rights, or anyone else. I don't care if they're in a car or whatever. No license. You guys got no evidence that they're work for DoorDash or carrying passenger property for a profit for any other place. You got nothing on. They're not doing nothing wrong. They're not driving a motor vehicle. They don't need a license or insurance or registration. None of that.
The entire time he's been talking, I wanted to get a little word in. I can't.
I got a copy of the order on my phone right now. The order that the judge signed to dismiss that charge for driving without license. Dismissed. That's my favorite. I got a copy of that order signed by the judge on the document. Know what I'm talking about. It's your violation, not mine. We'll see who you're dealing with. You're a dumb young kid and know shit about it. You're an idiot. You're never educated for a job. You'll buy me another one. I'm in the law school. How's that? It's going to be a better one. It'll be bigger and better.
Okay.
You'll see when I cite my law in court, you got no case. I'm going to prove how you're harassing. You're an idiot. You don't just ask someone where's your license at. You know that like I know it. This is a free country. You have no obligation to answer. You damn sure can't just demand it. Oh, where's your license at? For no reason. You ain't got no reason to say that.
I got a key for you.
You got a key for it? Holy cow!
Road truck is there.
Catch a ride. 19718.
We have a judge order it right back to me.
You'll be able to get it out.
Yeah, not paying shit. I might have
They're doing it.
to write their ass up on it.
Okay.
No damn way you can do it like that. Well, you're a young kid. I guess you don't appreciate the job.
Joey. Okay. Yeah, you need a driver's license
No,
to
you
drive.
don't.
Yes, you
And,
do.
and the law, I just showed you the law. I just cited the law that says you don't.
Okay.
18 U.S.C. 31 and U.S. Supreme Court case law that already beat the case in Southgate for. Did you see that on the computer?
No, I didn't.
Okay, you didn't look it up. That's why. I can show you on my phone the order I beat the case. Same bullshit. I don't need a license because I'm not doing it for profit. Just like the Southgate told idiot cops.
Hey.
Then I'm gonna sue. What's the fact?
Calling you names.
You guys are here telling me what you mean.
Right.
You're doing worse than calling names. You're taking my property. That's my personal property. I got constitutional right to have.
You can take
You're
your stuff and
stealing
you're
my
free to go.
property. I'm going to go down there now and file larceny charge on it. Well, when I get time tomorrow, whatever.
Okay.
Larceny. That's what it is. You got no right to do it. You can cite it in state law. You can. It doesn't override the Constitution.
Okay.
Stupid kid. You're a dumb kid. That's what you're not going wise. You're walking behind you. Being wise and smart. Maybe you get older wise. Maybe. I'll be hooking up tonight to the judge. Demand to order that place there to give me my stuff back. And if he doesn't, he's got to do it by the Constitution. He doesn't, he'll be violating the Constitution. Either way, I got all you on constitutional violations. So that's that.
Sir.
And eventually it will be getting back. And thousands for violating that right is coming out your pockets.
Okay.
You're not committing negligence here, so don't think the state's going to pay for it. It's called qualified immunity. You're not entitled to it. Meaning you got to pay us your paychecks when I win the lawsuit. You know, like I know it. So, save your piggy bank up. I'm coming for it.
There's your,
I love playing these legal games. That's why I do law for 8 years.
good for you. I don't give a shit what you play, okay?
You
Take your
think you
glasses
love
and go.
harassing, but I'm not the
I'm not
ignorant
harassing. You
citizen.
need a valid driver's
Yeah,
license
you
to
is.
drive.
You
Okay.
stopped and harassed right after, but you had no business even stop.
I did.
Stop. No, you did.
Broke down vehicle on the roadway.
What?
Impeding traffic.
You're lying. You don't have camera evidence. Due process
Fine.
violation
Take
right
your
there.
glasses and get on.
Do you see how it's smart on top of my head?
Yeah, you're really
I don't need
smart.
to read a book. I already read all this.
I know,
28
you're
years
very
ago.
smart.
That's right.
You're really smart.
What's your
In
number?
court, this is I'm gonna be drilled the shit out of you.
What's
You
your
got
P
camera
number?
evidence to say I was doing this? No, exactly.
Take your glasses.
Due process that must be dismissed. You're just wasting your time getting yourself in trouble.
Have a good day. Have a good day. Have a good day. Have a good day.
You're a low life piece of shit.
Ringing 3, ringing 8.
You want your ID back?
You already did enough stealing.
Yep.
And that's why you get larceny charges. And I do not follow myself.
Okay, you can go right down to the front desk of the police station and file
Yeah,
those.
you guys can ignore me. I can file right in the court. See?
Go
That ain't
ahead.
gonna stop me. I know how to file right in the court.
Go ahead and do it. Go file
The
it.
Michigan Constitution gives me that right.
Go file it.
You should have took my key either. That's my property. I'm gonna write you up for that too. That was stealing my
All right, write me up.
Recap, City of Taylor.
All right. And for the defense?
Good morning, Your Honor. Attorney Josh Hadley. I appointed counsel on behalf of the defendant, Mr. Eric Martin. Briefly, Your Honor, I'd like to make a record. We were before this court last week and there was a motion, a pro se motion filed by Mr. Martin to have me replaced as counsel. I was never served a copy of that. Your court graciously did send a copy. I have had a chance to review it. Your Honor, I would just again state that if Mr. Martin and I have a fundamental disagreement as to trial strategy pursuant to People v. Charles O. Williams, 386 Mich. 565, 1972, good cause exists for a substitution of counsel. If there's a difference of opinion between the defendant and the appointed counsel with regard to a fundamental trial tactic, as well as going to People v. Bass, 88 Mishap 793, 1979, good cause can also be found. There's obstruction of communication and breakdown. Now, my recollection, Your Honor, last time in denying the motion was really how late in the game the motion was. It was going to be prejudicial, essentially, and disruptive of the judicial process.
That's correct.
If I recall correctly, one of the other concerns we addressed was the concept of Mr. Martin's belief, which I think we've now clarified, that I'm not restricting him from speaking in any way, shape, or form today.
Nope.
Very well. Your Honor, I would also like, I believe, again, I don't want to put words into this court's mouth. My understanding is my role today, as if Mr. Martin wants to advance the defense that he has selected, I'm here to aid him with the understanding of the Michigan court rules, the Michigan rules of evidence, and all federal and state applicable law.
That's correct.
Very good, Your Honor. Okay, because of that, again, I think I just, for Mr. Martin and myself and this court and the people to be on the same page, for these reasons, I will not be making an opening statement, or I will reserve an opportunity for a closing argument.
And I will say this, I'm going to go ahead and give the ground rules to Mr. Martin so that he understands. Mr. Martin, you are lead counsel. You are your own lead counsel, and you choose to be representing yourself. Is that correct?
Present myself, not represent. I am myself, but
Listen,
I'm not presenting myself
I'm
as
going to tell you this right now. I'm going to say it one time. I'm not going to sit here and split hairs on meanings of words. To represent oneself or present oneself means the same thing. You are speaking on your own behalf. Yes?
right. Yeah.
Great, very good. Both of them mean the same thing. So we're not going to play semantics because literally I'm a walking thesaurus. So I'm not going to do that. And I'm going to shut that down because you're just going to waste time. And I'm not here to stall and waste time. I'm here to make sure your due process and you have a fair trial. And as part of that fair trial, you're not going to try to disrupt the proceedings by either stalling, playing semantics with, well, it's present instead of represent. It literally has present in it. Represent just means to redo it again. That's all. And so every time you get up, you're just representing yourself again. You're representing is what it means. That's what represent.
I make up the semantics it does.
So anyway, so here's the thing. You're going to be the lead counsel, so you're going to do your opening statement, things like that. You're going to follow the court rules. You're going to follow the same rules of evidence that everybody else follows. Mr. Greco is not going to have any advantage over you. You're not going to have any advantage over him. If you literally have a legal encyclopedia sitting next to you, someone who is very competent in the laws and the court rules and the statutes and the rules of evidence. So if there's an objection or things like that, I will pause. So that if you think that there's an objection and you think that there is something like that, I'm also going to ask you, because you have someone who is so astute at trial practice, if your co-counsel, are you giving your co-counsel permission to say objection when he sees something objectionable that you don't recognize? Because I'm just saying you don't have a Juris Doctorate, you haven't formally studied the rules of evidence in a formalized setting. You could have done so online or anywhere else by library or by book or whatever. I don't know that you have or haven't, but I don't want to presume. But I just want to know for the flow of things, because if someone says something, they're going to keep asking questions unless somebody jumps in with an objection. If you don't recognize the objection, but he does, are you giving him permission to assist you by saying, hey, hold up, that was objectionable?
Yeah, as long as he's going by the law and not doing nothing that's going to violate my rights.
Well, I just want to know. I mean, and I'm making sure that this is your protection. He's there for your protection. I'm asking this question because just from a flow of trial standpoint, somebody who knows what's going on would be, because I do it all the time, sometimes sitting here. Like someone will ask a question and I kind of like, I'm watching. And I would have said objection if I was the other side and they don't object. And I don't even know if they didn't pay attention or they didn't know, or I don't know. But I can't do that for you. I have somebody here who is very astute at that. Are you giving him the power? I know you want to speak for yourself, but this is the one situation where you have to respond like right now. You have to like block, you have to like do something. And if you don't recognize it, I want to make sure that you are giving him permission for him to do that. Is that okay?
How long do it, but I also reserve my right to also make.
No, sure. I mean, and all I'm saying is I'm going to have him call the timeout. I'm going to have him tell the timeout flag by saying objection. Then you two of you can talk about why it's an objection and then speak to the court. Because if obviously you didn't see it or recognize it, he did. So there's probably a reason why, because he's not just going to throw out the word objection for every little thing. You're also not going to throw out the word objection for every little thing. Because if you say, I'll give you three. If you came up with three frivolous objections in a row because you don't know the court rules, then I'm going to turn the case over to him because he knows how to do it. You understand what I'm saying? I got no problem with you and your closing argument, your opening argument. Sure. If you want to cross-examine a witness, sure. But it better be within the rules. It better be as to the elements. It better be as to the case, not anything in some other tangent about anything else. It has to pertain to relevance. because every single piece of evidence, I'm just going to give you a quick update on the rules of evidence. The first rule, Rule 401, is that all evidence must be relevant. So if it has nothing to do with the elements of driving on a revoked license, I don't want to hear it. If it's anything to do with bias, yes, you can go into bias, because that is one of the things that you can bring up under Rule 403. But under Rule 403, there's also overly repetitive evidence. So if you're going to ask the same question 20 times, just in 20 different ways, you're going to get an objection, and I'm going to sustain that objection. You understand what I'm saying?
Comprehend.
Okay, very good. That's all. And I just want to make sure, so that, because everybody who's here, who's going to be in a jury, they have a right to serve as jurors. And I'm not going to have them sit here for an extra hour just because you want to play semantics, because now you're violating their rights perhaps by doing that. But I want to make sure that you have full representation. I want to make sure you have full due process. I want to make sure you have access to an attorney. And again, I'm going to ask you, are you knowingly and voluntarily choosing to not take house counsel? You're going to represent yourself as lead counsel?
Again, like I said, before.
Just a yes or no. I mean, are you representing yourself as lead counsel, or knowingly and voluntarily?
I reserve my right to say what I want to say and help myself in the case, but it's also okay for him to, also want him to do his duty and offer me the effective.
So that's what I'm saying. It's like, I don't want to leave him in a position where he doesn't know exactly what his duty is. He's either lead counsel, or he's just a helper who's just going to sit there. Unless you ask him a question, he's not going to do anything. That's what I'm trying to ascertain exactly what it is you want from him. Officer Rose, good morning, sir. I'm well. I'm always well.
Okay, well, first remember, Slavin, you said yourself, you said it was okay, Judge Slavin, you said it was okay that I say what I want to say, and you said it basic. So I don't see what the questions.
But the questions aren't so much for you. The questions are basically because I want to define the parameters of what your co-counsel is going to be required to do. Because I'm not going to have a situation where you're like, well, he didn't say objection on this one time, and he could have had an objection, and now I'm going to sue him. Because you're asking me to appoint him, sort of, with one hand tied behind his back. He's either going to be able to do his job to the fullest extent and represent you as a zealous advocate that he is, or he's going to be an encyclopedia of legal knowledge sitting there only waiting for you to take the book off the shelf. I did create that one situation where you could let him carte blanche. If he thinks there's an objection, say objection, which will just basically be a timeout. Then you can group or powwow, whatever you want to call it, about what that objection would be, and then we'll proceed and I'll make my ruling on it. But other than that, he's not going to jump in, chime in, any of that. Is that what because you're running the show on the representation, correct?
Well, yes, but I was going to say
there's no.
I want to give up my right to effective assistance of counsel.
Right. Well, that's what I'm saying. You either are going to accept it or you're waiving it. There's no half waiving it. You understand what I'm saying?
Eric Martin always has to say something. It's never smooth with him. The Judge Slavin's trying to make it as good as he can, and they're giving him the rules, and he always has to throw a monkey wrench in it.
I'm just making sure what it is, because I don't mind whichever way you choose.
Based on what he just told me, I should say lead counsel based on not just because what he told me, but.
So based on, well, first,
like I said, I'm going to do this job.
Hold on, because I don't want you to say, because I don't want to hear whatever private conversation you had between the two of you. Because I know you just said the words based on what he just said. I didn't want you to say whatever, because that's private. No one can make anybody testify what you two talk about. That's privileged. If you say to the court, or if you say to anybody, anything he said, it removes and washes away all privilege to it. Okay, so I'm just letting you know that. So you understand. So any conversations you have with counsel, even though he's not technically counsel, but he's your assistant counsel, any conversations you have are privileged. So unless you say, well, he just told me this, well, now you just threw it. So I'm just trying to lay these ground rules so that we don't run into this during the trial anytime. So that you understand and agree. And I just want to make sure that you are knowingly and voluntarily choosing to represent yourself, knowing that I would have given you full access to an attorney. you're choosing not to take that access and you want to represent yourself. That's correct?
I'm choosing to present myself, but also I'm not waiving my right to be helped by him because I still have the right to do it. So I was still.
Okay, so if he sees any objections, he can do objections, but other than that, you'll just stop and ask.
And if and like I said, then
Okay.
we can't, I ain't predicting the
Just
future,
making
so I
sure.
don't know what's gonna happen. You don't, but as long as he don't say something.
Sure.
Violates my rights. If he does, then I'm gonna let that be known. I'm gonna object to him, whatever, doing
Well,
whatever.
see, now we're right back to, all right, so you know what, I'll just play it by ear. And if I think that you're doing anything at all that's contemptuous or just trying to stall on this, then I'll make my rulings at that point. But let's.
I feel very comfortable with the understanding of the speaking objections, just so I'm on the same page. Everything else I will serve in a co-counsel role.
Yep.
Until directed otherwise.
Yep.
Very good, sir. Thank you.
Very good. All right, so now, as to the motion. Doesn't have a motion. Oh, I just. So if they can't hear, I don't know what they can't hear. I don't know. It's not my problem. It's for the public. I'm not sure what's going on. Guys.
Possibly. I have a copy of the motion that you filed this morning. Okay, just want to make sure that. Yeah.
All right, so. All right, so I see you filed a motion this morning. This motion is a motion and demand to dismiss or discharge this case based on equal protection clause violations. And I have read through your motion. And did you give your co-counsel the opportunity to read the motion? Just in case if he asks you any questions, or if you ask him any questions.
Your Honor, I have had an opportunity to review all of the pro se motions that have been filed in this matter. So yes, I am.
Including the one this morning.
We had a chance to review it together.
Okay.
Yes,
All
sir.
right, good. Just want to make sure in case you need to assist in that way.
I guess I'll just add, I have nothing to add.
Sure. All right, so this is your motion, Mr. Martin.
Yep.
And basically it states that you think that there's a conspiracy between the police department, Officer Borg, Mr. Greco, and myself to prosecute you and keep you from getting your moped back. Is that basically?
Not just that, it's not completely, totally current. So, okay, so the prosecutor called herself supposedly prosecuting me here on this case when I have sought to prosecute Anthony Borg for stealing my moped, which is larceny, without my consent in violation of Declaration of Independence of 1776, along with my due process rights of the Michigan Federal Constitution. Okay, he had it towed immediately. And like I said, I filed actually state criminal charges myself with this court. They haven't been acting on. Greco here has not made no effort to prosecute it. And basically, like I said, so that violates my equal protection right. You know, if I'm being prosecuted, I have the right to prosecute when crimes being committed against me. But that hasn't been respected in violation of my crime victims' right of the Michigan Constitution, you know, in addition to the due process. So yeah, like I said, so it violates equal protection clause violation, not allowing me to prosecute also for the crimes committed against me. Therefore, the case should be dismissed based on that.
And Mr. Greco?
Yes, very briefly, Your Honor, I just had an opportunity to look at it, and this motion has no basis in fact, law, or logic. Mr. Martin is being prosecuted validly because he was operating a moped on the road with a revoked license and or no valid license. The moped was taken by area towing at the time because it cannot be on the side of the road and not left in his custody when he is refusing to acknowledge that he is supposed to have a license to operate a moped on the road. There is no basis to charge anyone else criminally or conspiratorially in this matter. So it should be denied.
All Judge, can I respond to that?
I'm sure.
Okay, well, first of all, state statutes cannot violate the Constitution. As we know, and the Constitution clearly says that property is not to be deprived before a due process of law, before a hearing. That was, as you just admitted, it was taken by your told immediately. You know, without before a hearing, without any due process of law. It did violate due process. And and besides that, based on my right to travel, my right to own my private property, I was supposed to take it anyways. So the state, even there's a state statute that seems to allow it, it's an unconstitutional state statute, and that doesn't override the Constitution. Again, the Constitution says private property is not to be deprived.
All right,
so
based on all the testimony that I just heard and reasoning, plus after having read through the motion, I am going to deny your motion. There is no violation of equal protection under Michigan Compiled Law 257.252A, which is the abandoned vehicle statute. Anytime that there's a situation where a vehicle has to be abandoned, obviously the driver of the vehicle was arrested for not having a driver's license. That vehicle can't just sit there on the side of the road, because why? Well, that's the city's job to protect that, and it also becomes evidence of of what was taking place. So that has to be impounded pursuant to the abandoned vehicle statute. Additionally, the due process that you say you are not going to seek, you actually will seek, because it's built into Michigan Compiled Law 257.904B, which states that when a person is convicted of an offense that's punishable by that section, the local ordinance, basically for operating a motor vehicle while their license is either suspended, revoked, or denied, the court shall order that the motor vehicle, if it is owned in whole or in part by that person, and the court shall order that the vehicle be impounded for not less than a period that the court orders, but not more than 120 days from the date of judgment. But what happens in the meantime and in between time is an actual trial that we're about to have right now. So that is the due process that the Constitution affords, because if it's found not guilty, then your moped gets put back to you. There is no cost assessed to you. The city will pay any cost for impoundment and fees. Why? Because you're found not guilty. You're stating that you're not getting due process. Well, we're about to start the due process, which is the trial. So for those reasons, your motion is denied. Now, you can put that in the file. Put the here. Denied for reasons stated on the record. Right. Now, with regard to one other supplemental thing. So the civil infractions that are in here, the no proof of insurance and the defective tires, those both stem from the same incident occurrence?
That's correct, Your Honor.
And are we setting these for a formal hearing? Are we having these as a formal hearing now with regard to these as well?
However the court wants to proceed. I mean, if we have a jury, we've got a jury. I mean, we can
Because
do.
the jury doesn't do these.
Right. I mean,
So
if you want to do.
because what I'm saying is, I have no problem if you're going to put in evidence and it's going to be the same witness, and I got everybody here, I will make a ruling on these after and outside of the jury's decision-making and vision. So they're not
Yes.
going to see that, so they won't be influenced in any way by it as to, well, the judge said he's already responsible for those, he's probably guilty. They won't hear anything from that. I'm just saying I'll make that a separate ruling on this, but we're going to have the formal hearing with regard to these, because I think having a trial on this is about as formal as you can get. So, but all of the decisions and everything about these will be outside of the jury's presence, because I don't want to taint the jury to think that, you know, oh, well, the judge said he's guilty of the other things, so he's probably guilty of this. They're not going to hear any of that. Just put it in your evidence and I'll make sure of it afterwards.
Okay, fine. That's what we'll just address it during the
That's
correction
going to be
process.
part of
That's fine.
it. And Mr. Martin, with regard to that, you'll be able to cross-examine about anything like, you know, the tires. They won't understand what it has anything to do about anything, because I'm not going to instruct them that they're even thinking about that. I'm the one who'll make the decision on that, because these aren't jury trial things. It's just civil infractions. So, and that way it's not going to, they're not going to get into it or about anything or hear anything about it really, other than they're going to hear the evidence for everything. I need to hear the evidence about this. So if you have any cross-examination with regard to defective tires, if you have any cross-examination with proof of insurance, you know, I don't know, maybe it was on your phone, maybe it was in your pocket, or I don't know. I don't know what, I don't want to put it, I'm just saying, you can ask about all those things and make sure you're doing that, because we are having the formal hearing on these as well. So they won't understand that it has anything to do with their stuff. I'll make that determination after they're gone. So that way it doesn't change their viewpoint of view, okay? So.
We're clear, Your Honor.
Okay, very good. So let's go ahead and,
Before we
any other supplemental matters?
I think there was one outstanding motion that at our last pretrial hearing, Mr. Martin attempted to address with the court. I believe it was filed. I see a motion with an October 25th date. Is this the same argument?
October 25th.
Your Honor, it's a motion titled, motion for demand to dismiss, discharge these cases based on the attached legal arguments titled nobility. I don't know if the people were served a copy of this pro se motion. I did get a copy from your court staff.
Okay.
Let me converse real briefly with my client to make sure he wants to move forward with this argument. Okay, my apologies, Your Honor. He is ready to move forward with this argument.
All right, so the only other outstanding motion, and then the last time we were here, I said on the day of the trial that we'll clear up any outstanding motions that had not been heard. The only last motion, and obviously you filed a new one this morning that you brought with you, and we heard that, we discussed that. So you have this other motion for demand to dismiss and discharge these cases based on the attached legal arguments of title of nobility. So give me 1 second too, because I don't know if it's, did you have attachments to that? Because I see you got your handwritten.
So
You got your hand, when I was saying, I have your loose leaf handwritten motion like I see on your normal motions. But then I see like some pages that are, I don't know, it says page 49 of 88. So there's not 88 pages to your motion.
It was in the maybe I should have crossed some page. That would have been a little more professional, I guess, but you know, let's.
No, I'm not.
Yeah, I'll tell you how many pages that should be here.
I'm not speaking to your professionalism. I just want to make sure that I'm not missing the other 88 pages. That's all.
Okay, yeah, that's on the page now. 5, 6, 7, 8. I'm counting 18 here. 8 in addition to the motion of the actual legal argument. You know what I mean?
Okay, so I got 4 pages of, I got 4 photocopied pages and then 2 handwritten. So 6.
Motion to dismiss. 6, you have 6 total pages.
6 total pages.
Hold on, I think you should have 8. Let me see.
One of the pages that's in our possession is a blank page that's looks to be a photocopy of a hand, just loosely notebook.
Let the record reflect. I'll just go through what the court has. You tell me if I'm missing something, okay? So I have dated October 25th. It seems to be your title page where it says regarding City of Taylor versus Eric Martin. And it says sincerely Eric Martin in red. This is your opening first page. And then I have the motion heading page based on the attached law that is in demand. It is demanded that to take judicial notice of, okay? And so that's the 2 front pages. Then I have
8 pages of a legal argument. I just 8 more pages I should have.
So there's 2 handwritten. And then there's 1, 2. So I have page 49 of 88, page 51 of 88.
That should cross out maybe, you know, maybe
Page
more
53 of 88.
number of the pages.
I know, well, that way, I mean, they're numbered, but I just want to make sure these are the numbers that I'm supposed to have. 49 of 88, 51 of 88.
Wait, where's 50? 40,
53 of 88, and 55 of 88.
Oh,
Those
you
are the
went
ones
from
I have.
49 to 51. This is skipping the page.
Well, that's,
49,
I don't
50
know, I
up
didn't
to-
file it, I didn't give it to myself. That's
Right,
all I
so you
have.
should have 49, hold on, let me look at it. Let me see.
So
You have 49, 50, 51, 52.
I have a working theory on this, Your Honor.
I don't have 50.
pages. I have pages that have the court stamp every other page. My suspicion is this was double-sided. Did you write that? Were these printed double-sided?
No, I didn't send them double-sided, so.
May I approach the judge with this?
Sure, if you could just take page 50, because I don't have 50, I don't have 52.
Your Honor, let the record reflect I'm approaching with the entire motion, Mr. Greco. you wanna go?
Judge, just looking from here, it looks like yours are double-sided.
Oh. Yeah, see, mine are double sided.
Yeah.
Okay, hang on a second now.
Okay,
Yeah.
so that's what I'm trying to get us into. Here's your motion.
All right, so yeah, I got 50 on the back. So I guess you did print it double-sided or something, or?
Sorry for the interruption. It just sort of looked
No,
like that's what
a
happened.
good call, good pickup, but the record reflected that also violates the Michigan court rules with regard to pleadings, but in an improper state, I'll go ahead and take it in the light most favorable to the improper defendant. So, all right, so Mr. Greco, do you have a copy of this motion?
I do.
Okay, you do. All right, so Mr. Martin, go ahead with your motion.
Yeah, so with this motion, some of basically what's already said in here is, the driver's license. Okay, the US Constitution started with Article 1, Section 10, the state's prohibited from granting titles of nobility. The driver's license is a title of nobility, it's a special privileges for so-called drivers, and it's prohibited.
Okay, so do drivers get the nomenclature of king, duke, duchess, governor, but what specific nobility titles are given to people who are drivers?
As it says in, like I put in here, it's a privilege granted to a certain, right here, a title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8, page 40, a driver's license is a privilege which is granted by the state as a corporation.
Sir, I am going to ask that you not mumble. You're going to speak up because it's hard to hear. I can barely hear you, and I know that Ms. Hancock is going to have a hard time trying to make a record of this.
Yep, this the title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8, page 40. A driver's license is a privilege which is granted by the state. There's a lot of arguments here, but basically sum up, like I said, the driver's license title of nobility, it's a special privileges granted to so-called drivers, a certain select group of people, and US Constitution, Article 1, Section 10 prohibits the state from granting titles of nobility.
Mr. Greco?
Yes, very briefly, Your Honor. The argument that he's asserting with regard to this applicability to driver's licenses has no applicability whatsoever. As the court is aware, being a constitutional historian and an American, that the titles of nobility was a big deal at the time of the founding of our country with respect to nobility titles such as that you described as king, duke, things that would be granted to somebody just by either right or granted certain rights by that title that have no application whatsoever to a state issuing a driver's license for those that are able to obtain one in the state. There's no applicability whatsoever.
So I will note that the Oxford Dictionary defines nobility as the quality of being noble in character. That's one. Two, the quality of belonging to the aristocracy. So, like Mr. Greco said, that's like you're a monarchy or whatever your setup is, like in England, that kind of thing. Duke, Duchess, all that good stuff. So, contrary to Roger Miller and the fact that is anybody who's the king of the road, it's not true. There is no nobility that comes along with driver's license. When they use privilege to talk about privilege, that is in opposed to a right. You can either have something that's a right, or you can have something that's a privilege. And a privilege is something that can be regulated for the safety, health, safety, and welfare of all citizens. Like I said, you keep talking about a right to travel, you got a right to travel. You know what? You can walk anywhere you want to. But if you're going to use something that can hurt somebody else, that needs to be regulated, such as a plane. You can't just go and buy your own helicopter and just, you know what, I'm tired of all the traffic jams. I'm just going to fly my helicopter from my backyard, land it on top of the courthouse, and then I'm going to just, park here. You know, you can't do that without a pilot's license. Why? Because you could literally kill people, like if you fall out of the sky. So there's a reason cars can kill people. It's no different than why you have to have a permit for certain weapons. We have a right to, and that's sort of the clear right to keep and bear arms. But you still have to have certain weapons. You have to have a permit for those things. And, you know, so there's regulations that go along with that for the health, safety, and welfare. And giving a driver's license is because we want to make sure, the state wants to make sure that anybody who's driving has the basic knowledge and understanding of what it takes to drive safely, so that it's going to be for everybody, for everybody's benefit. So with regard to the violation, there's been no deprivation of your constitutional rights, and there's been no violation of the Constitution. And the fact that you need to have a driver's license is something that has been ruled upon by the Michigan Supreme Court, by the United States Supreme Court, and the right to travel does not supersede your ability to need a driver's license. You can travel all you want to, like I said once before. You can walk yourself all the way from Forrest Gump from here to across the country and all the way back. But you got to do it by walking, maybe even riding a bike or something that doesn't require a license. But for licenses, certain things need licenses. There's a reason for it. And all of those have been hundreds of cases that say, yeah. So for those reasons, your motion is denied. So now let's begin by bringing in the jury.
If I object to that, I'd like to respond to something that you.
There's nothing to respond to. I've made my motion I made my ruling on your motion, and your motion is denied. If you want to appeal it, you can appeal it to the circuit court, but that's between, all right, so.
I will be
Right
appealing
now,
actually.
we're getting to the.
All the verses, I'm going to provide notice that the court will be appealing all the issues that's
Duly noted.
diverse and
Duly
deny
noted.
my motions and demands based on.
All right, so I have, Detective Hinojosa is going to sign in real quick because he has 3 different felonies to swear in.
Just gonna step outside for a moment, bro.
Sure. So I'm going to give, we're going to go on recess, probably 10 minutes.
Sounds great, Your Honor.
So what exactly, where is this hearing officer from?
Michigan.
Livonia, Michigan. So I'm going to make a ruling in limine that this guy from Livonia, how does he have anything to do with the allegations that happened on the day of you driving your moped without a license?
Because, okay, now.
Was he driving? No. Yes or no? Yes or no? Was he driving?
He denied me my driver's license. I tried to get it.
Okay, then that's between
Under
you and the
threat
state.
of arrest, I tried to get the driver's license.
That's between you and the state. And that has nothing to do with him, and he can't even be called as a witness in this case.
So until he violated my due process, like my
That's
granny,
between
then he
you and him and the state and any sort of 42 USC 1983 case that you want to go file, you go ahead and take care of that in federal court. But that guy has no relevance of any kind of anything in this case. He wasn't at the scene. He wasn't making you drive. He wasn't there driving. He wasn't riding piggyback with you. There was nothing going on. So this hearing officer from Livonia who denied your driver's license has nothing to do, absolute zero relevance. I am the gatekeeper of evidence. Rule 401 specifically says that 402 says all evidence must be relevant. And if it's not even admissible. I'm going to tell you that right now. Whatever this hearing officer from whatever you did to try to get your license back, restoration in Livonia has nothing to do. He has absolutely zero relevance in this proceeding. So because of that, under the rules of evidence, I can't allow him to even testify because he has nothing to do with anything. So because he doesn't need to testify, there can't be any defense based on him because he has nothing to do with your case and the allegations of you breaking allegedly the law. So your motion to adjourn the matter because you got to go get this guy as a witness is denied.
Let me explain further. I'll explain how it is.
There's nothing to explain further. I've denied your motion. I keep explaining. Once I make a ruling on the motion, that's the end of that. That's the end of the discussion.
I've
Counsel, is
advised,
there anything you'd like to add?
no, Your Honor, I've advised Mr. Martin, again, once this court's made a ruling, be it on spoken objections or anything moving forward, if there's continued to be banter, that he's been advised can be held in contempt of court. I appreciate the court giving us some leeway through this. Do we have any other preliminary matters? Your Honor is.
Yes, I do. I still have other things to say as to my rights, yes. And I have another motion to dismiss based on my rights.
What is your other motion to dismiss?
I move to dismiss because of the Declaration of Independence of 1776, governments derive their just powers from the consent of the government. I never consented to be ticketed. Never consented to these court proceedings. I'm only here by threatened arrest, because if I don't, could be arrested and all that, but it's threatened arrest. So it violates the Declaration of Independence of 1776 and also Article 4, Section 4 of the U.S. Constitution, my right to Republican form of government. This is all the flags right there, the gold fringe flag, that represents a military jurisdiction. I don't consent to a military jurisdiction. You can't hold it against me over my right to Republican form of government. It violates my right to Republican form of government by trying to enforce this military jurisdiction over me. These statutes, which is what it is, and my right to Republican form of government means my right to common law. And I demand my rights under common law and Constitution, my human rights and God-given rights. And that's been violated so far, but I move to dismiss based on that because the statutes, again, it's all under military jurisdiction. And like I said, it violates Article 4, Section 4 of the Republican form of government, which means no statutes.
All right, so you made a, Mr. Greco, do you have any response?
Yeah, my only response is that the entire argument is inapplicable here. It is subject to the laws of the state of Michigan and the United States of America, and is subject to this prosecution validly in this courtroom, which has jurisdiction.
I object to that. There's no evidence to support that. Yeah, well,
your
ask them.
Your motion is denied for the following reasons. You argue that basically this court lacks jurisdiction over you. And that's just not true. The question of whether a court has personal jurisdiction over a party is a question of law. And the plaintiff, which is here the prosecution, would bear the burden of just showing a prima facie showing that there's jurisdiction. And that's part of the elements. One of the elements is that all these allegations happened in the city of Taylor. And now, under Michigan Compiled Law 600.701, any individuals, it talks about individuals and it talks about general jurisdiction of the court. And it says basically that the existence of any following, the existence of any following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of this state to exercise general personal jurisdiction over the individual or his representative, and to enable such courts to render personal judgments against the individual or representative. 1, presence in the city at the time that you're served. So as soon as you got the ticket in the city, boom, that was the jurisdiction. 2, domicile in the state and or here in the city. You live in the city of Taylor, so your domicile is here. And the last one that you talked about is consent, and you said that you didn't give consent to, et cetera, et cetera. So in the present case, you are physically within the boundaries of the city of Taylor at the time of the alleged criminal activity. And because you afforded yourself the context and then that's as minimal context as you need for this court to establish jurisdiction. So for those reasons, and for the reasons stated on the record by Mr. Greco, your motion is denied. So now let's start with the voir dire.
If I get a chance to respond, I want to say something.
There's nothing to respond to. I just ruled on your motion. You came up with this motion last minute and you brought it up. I've thought about it and made a ruling based on the law. And if you think that I'm incorrect in that, you can file an appeal.
Yes, and I'm going to, and I request now that these proceedings be stayed because I'm going to be appealing these denials. You denied all my motions in violation of the Constitution. So I'm move for a stay of proceedings until the appeal is decided on this issue.
Motion denied.
Another one.
There's no need to. That's not how it works.
The person's appealing an issue. That's how it's supposed to be.
All right, so we're going to go off the record for a moment. All right, so
Another motion made to dismiss.
Say again, I'm sorry.
Another motion to dismiss.
And go ahead.
Based on the misconduct of police officer Anthony Borg. This was Anthony Borg, isn't it? I had a chance to look at his name tag. But anyway, is this Anthony Borg?
I'm not here to identify people or answer questions. I'm here to make rulings of fact and law, so.
Anyways, well, the police officer Anthony Borg that wrote the ticket. Okay, he was acting outside of his authority as a criminal law enforcement officer and acting as a civil revenue officer because the purpose of the ticket was to help make the city of Taylor richer by trying to impose fines, etc. And yeah, I'll move to dismiss on that. So that he was acting outside of his authority, it's misconduct on his part. So it should be dismissed based on that.
Mr. Greco.
Yeah, brief response. He was not acting outside of his authority. He's a police officer sworn by the state of Michigan and the city of Taylor, witnessed somebody committing a crime and issued a citation based upon that crime with this defendant committing that crime. That's why we are here. That's why we are alleging it. That's why we are pursuing the matter.
Additionally, I am, go
I'm
ahead.
gonna say that, I don't want to cut you off. So respond to him, can I respond to him? I'll respond to him what he said. Okay, now, isn't it true that the city is
You
getting
can make,
richer?
you can make argument, but you're not gonna ask questions of the city attorney. That's not.
What's part of my right to
No, it's not.
evidence to make
No, it's
argument?
not. No, it's not.
But,
This is
okay, well
not-
anyways, then I can ask the question, then I'm gonna say, I'll make the argument that, that's not true because the tickets, there is a civil thing behind it where, you know, money's involved, so
So,
it ain't just like what he said. There is a civil thing, there's truth to what I said. The
okay,
city
so
can richer
the,
off tickets and it's a civil, it's acting as a civil revenue officer.
so the penalty, the alleged or the potential penalty for violation of this crime is 93 days in jail and or up to $500 in fines. So if you get found guilty, you can just get 93 days in jail and there wouldn't be any money coming to the city. Matter of fact, the city would then incur a debt because they would have to pay, I don't know what it is, $37, $44, whatever it is, for every day that you're incarcerated. So actually, if we go through this whole trial and you get to be found guilty, you can get 93 days in jail and there might not be any civil part of it at all. That's entirely up to me as a sentencing judge. So, and I haven't heard any testimony, I haven't heard anything because we haven't started the trial yet. So your motion is denied because it basically has no grounds at all. That's his job, is to do police work. And if it's not, if the allegations prove that you're innocent, that's fine. If they don't prove the case beyond a reasonable doubt for all the elements, then that's going to work in your favor as well. But we don't know because we haven't got to the trial part yet. But that is his job. If he thinks that there's reasonable suspicion that there's a crime going on and he sees that there's probable cause that those crimes going on or happening right in front of him, then he is sworn and duty bound to act upon it. Whether or not he's correct or not, well, that's what this whole trial is for today. So your motion is denied. Now let's bring
On
in.
behalf of contempt, can I elaborate? I'm gonna elaborate.
No, you can do whatever you want on appeal, but I've made my ruling on the motion. The motion is denied. So let's bring in the jurors. Hi, good morning, everyone. Just go ahead and file in there. Then once it gets to be, comfortable, then just go to the next level and start filing in after that. And right there in the second row, just go ahead and slide in the second row there. And that's it. Yep, just anywhere, any of the benches there, just find a comfortable spot. All right. Ladies and gentlemen, I'm Judge Slavin, and it's my pleasure and privilege to welcome you to the 23rd District Court of the State of Michigan. I know that jury duty might be a new experience for some of you, and that's fine. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of government could not exist without it. So the jury is an important part of this court. The right to a jury is an ancient tradition and part of our heritage. The law states that both a person who is accused of a crime and the prosecution both have a right to a trial, not by one person, but by a jury of 6 impartial individuals. Juries must be free as possible, as humanly possible, of any bias, of any prejudice, of any sympathy for either side. And each side in the trial is entitled to jurors who keep open minds until the time comes to actually decide the case. So first, let me talk about the impartial aspect of being on a jury. A trial begins with jury selection. That's where we're going to start. All right, now I'm going to read to you this is a criminal matter. And the paper that's used to charge a defendant with a crime is called a complaint. And the charges in this case is that it is alleged that Mr. Eric Joseph Martin drove a vehicle on a license that was revoked. And that allegedly occurred on July 11th, 2023. So the defendant has pled not guilty to this charge. You should clearly understand that the complaint, the information I just gave you, is not evidence. Okay? A complaint is read in every criminal trial so that the defendant and the jury can both hear the charges. So everybody knows what the charges is, like why we're here. Okay? You must not think that it is evidence of guilt, or you can't think that he is automatically guilty because they've been charged. Now, does anybody in the jury pool know Mr. Greco? Your opening statements.
Yes, thank you, Your Honor. It is illegal to drive a motor vehicle on the road in the state of Michigan without a valid driver's license. It is illegal to drive a motor vehicle on the road in the city of Taylor in the state of Michigan without a valid driver's license or a revoked license. It is illegal to drive a moped on the road in traffic on a public street without a valid driver's license or with a revoked license. It is illegal to operate a moped on the road in the city of Taylor, in the state of Michigan, without a restricted moped license. If you are only between the ages of 15 and 19 years old. So if you're over the age of 19, you need a driver's license, a regular driver's license, requiring a road test, regarding issued by the Secretary of State. But if you are 15 years old, you can apply for a moped license to only operate a moped, but the Secretary of State will not renew it past your 19th birthday. You would have to get a regular driver's license to operate a motor vehicle on the road. So it's July 11th, 2023 at approximately 4 p.m. at Rocco and North Line Road. Officer Borg is on patrol. He observes an individual on a moped stopped in the roadway with what appears to be a flat tire. Person gets off the bike, the moped, gets back on after inspecting the tire, turns into Heritage Park. Officer Borg, you're going to hear testify, sees this, comes in behind the person because of the flat tire, and then at that time observes that he recognizes the person as somebody who he's dealt with before, who he believes is operating on a revoked or suspended license. We are here because the defendant, Mr. Eric Martin, was operating a motor vehicle, a moped, without a valid license in the city of Taylor on the roadway on July 11th, 2023. Now you might be saying to yourself, what could possibly be the defenses in this case? I'm not exactly sure. We got a little preview of them through some of the questions, but I believe one of them is going to be that my name is Eric Martin. I'm a living man. I'm not sure if I'm a person. I'm a living man, but I'm not subject to the laws of the state of Michigan or the city of Taylor. That is not true. I'd say I'm not required to have a driver's license to operate a motor vehicle, including a moped, in the state of Michigan, in the city of Taylor, because it's unconstitutional that the state and or the city of Taylor require an operator's license, driver's license to drive on the road. Not true. He might suggest that he wasn't operating a motor vehicle that day or driving a motor vehicle that day, that he was traveling, and that under the Constitution protects against interstate travel. He was doing none of those things. He was operating a motor vehicle, which the state of Michigan regulates by driver's licenses, by having certain requirements, and then certain things that you can do to get your license revoked, which we're not into here. The fact of the matter is on July 11th, Officer Borg pulled over an individual operating a motor vehicle in the city of Taylor without a valid license and, in fact, a revoked license. I'm confident after you hear the judge give you the jury instructions, and he already read to you what is going to be the jury instruction before, of what the requirements of this case, of what the prosecution has to prove, that is simply that the defendant operated a motor vehicle, that the defendant operated a motor vehicle on a highway or a place open to the general public and accessible to motor vehicles, and third, that the defendant's operator license was suspended or revoked. You are sitting on the jury. You are the fact finders. You are the fact finders that finds what you believe is true and then apply it to the law as the judge indicates what the law is to do, and then determine whether or not the defendant violated the law. I'm confident when you hear all of the proofs in this case, after you hear the testimony and any further argument that there may be, that you will find the defendant guilty. Thank you.
Mr. Martin, your opening statement.
Ladies and gentlemen, jury. Okay, so I'm a living man, one of the Southern people, fraudulently assumed defendant. Again, I know that might be above your guys' head because that's something more someone knows that's been studying law for 20 years, more advanced stage, but it's backed up by laws called Roman Gate Trust, corporation, a defendant. But anyways, I got some proof to prove that, some laws going to prove that. The law applies that someone, actually the words used specifically in state law, a person must have a driver's license to drive a motor vehicle, okay? So that's the first fraudulent thing that's being done here. I'm a human being that's being fraudulently assumed to be the person. And I'm going to show you a Supreme Court's case law that says a person is not one of the sovereign people, as a person is defined in statutes. This is the U.S. Supreme Court talking here, not just me. Now, this whole case started from the harassment and retaliation of Anthony Borg, the police officer. He sees me riding down the street and calls me over, hey, come over here. And he had no probable cause. Just he recognized me as one of these, I'm a prolific complaint writer on the cops' misconduct, him and his friends. I don't have all the complaints with me now. I wanted to have them, but it was, the last stage. I thought about bringing all that. I tried to, I wanted to adjourn the trial, actually, so I can get that evidence and show all the complaints I filed. So if there's going to be any dispute whether I filed a whole bunch of complaints with the police, which supports my retaliation claim, which is the whole reason why this case was brought up by him in retaliation, because, like I said, I filed a lot of complaints on his officers. Now, besides that, as to a flat tire, you can kind of see it's kind of obvious that this is not just a case where he's enforcing law doing the right thing. You see someone with a flat tire. Is that a reason to pull someone over? He wrote that ticket actually on a flat tire. Having a flat tire. Talk about nonsense. Talk about harassment, retaliation. Like having a flat tire is something wrong in this world. When someone gets a flat tire, what is wrong with it? Nothing. But he writes a defective ticket for that. That just shows, like I said, his retaliation, his animosity against me. But none of this will scare me and discourage me from enforcing my rights. I've been doing this 28 years. I'm going to keep doing it. I'm one of God's righteous soldiers and warriors who stand for my rights and the people's rights. I truly represent the people. These guys on the other hand, they don't represent the people. Probably what they represent the city, a corporation that wants to make money out of people's rights, violating people's rights. Such as this. This is all about really the charges about me exercising my right to travel on my moped. Okay, and I don't dispute that I was traveling by right on my moped. Now I know the state law. Well, maybe it's more for an argument, but without too much detail. I'm supposed to be more briefer. But basically, it's about me traveling by right. You know, despite what he says, the U.S. Supreme Court says we have that right. He calls it not traveling by right. But as I'm going to show you word for word the U.S. Supreme Court case law in the closing argument, that I was traveling by right. And I ask that you guys, like I said, do the right thing. Thank you for your time.
I am going to, before we begin, I'm going to further instruct the jury that any law that you're going to hear and consider is going to come from me. I am the one who is going to tell you what the law is, because I am the one whose duty it is to tell you what the law is and what the instructions are. You'll hear facts from the parties, but any law that you hear from the parties, you can disregard, because that is absolutely going to come from instruction from me. So.
Objection, I object to that. You saying I can't make a legal argument?
I didn't say you couldn't make a legal argument, sir. I said that any instruction in the law, they're going to hear from me. I'm just making sure that they understand that where the law that they're going to apply and where that law comes from, and that's going to come from me, because that's the way it works. And with regard to Mr. Martin's statements that I have, or this court has in any way, shape, or form violated its constitutional rights, I'm going to just note for the fact that this court has been nothing but patient to make sure that Mr. Martin has been able to make a record about everything he wants to make a record about. And there has been no violation of any of his constitutional rights. So I'm not going to mention any of the motions that were made, even though he mentioned them. You're going to disregard any of those because those are not evidence. That has nothing to do with the case itself. So we're going to proceed with the first witness, Mr. Greco.
Yes, thank you, Your Honor. The City of Taylor calls Officer Anthony Bohr to the stand.
Officer Bohr, do you solemnly swear affirm the testimony about to give us the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please be seated, sir.
Okay, Officer Bohr, please state your name for the record.
Officer Anthony Borg.
And are you currently employed?
I am.
And where are you currently employed?
The City of Taylor Police Department.
Okay. And what is your position of employment there?
I am a patrolman.
Okay. Does that include, do your job duties and responsibilities include traffic law enforcement?
Yes.
Okay. How long have you been a member of the City of Taylor Police Department?
Approximately 5 years.
Okay. Are you assigned to a specific detail or patrol?
I'm currently assigned to the traffic bureau.
Okay, so this is what your regular job is traffic enforcement?
Correct.
In addition to general police duties?
Yes, sir.
Okay, thank you. All right, I want to take you back specifically to July 11th, 2023 at approximately 4 o'clock in the afternoon, okay? Were you working that day?
Yes.
Okay. Do you recall where you were in the City of Taylor at approximately 4 o'clock that day?
I was sitting in the entrance to Heritage Park off of North Line Road.
Okay. And what were you doing there generally?
At that time, I was monitoring the traffic at the intersection of North Line and Racco.
Okay. Do you recall encountering a person or a human by the name of Eric Martin that day?
Yes.
Okay. And is Eric Martin in the court today?
Yes.
Okay, where is he?
Sitting at that table in the collared white shirt.
Okay. For the record, Your Honor, I'd like to point out that the witness has identified Mr. Martin at the defense counsel table.
So noted.
Okay, what were the circumstances under which you encountered Mr. Martin at that day and time?
I was watching the traffic at the intersection of North Line and Racco when I observed a red moped traveling northbound on Racco Road approaching North Line. At that time, the light for the northbound traffic on Racco was red. As the moped approached the intersection, I observed what I believe to be a flat tire on the rear of the moped. While the light was still red, Mr. Martin exited off the moped in the middle of the roadway, walked to the back and was looking at the tire. While he was doing this, the light turned green. After approximately 2-3 seconds, he proceeded to get back onto his moped, where he crossed over North Line Road into the entrance of Heritage Park.
And what did you do at that time?
At that time, I was waiting for, as I was parked stationary in the entrance to Heritage Park, he was traveling towards me. I was waiting for him to get to my location, and I was going to initiate a traffic stop for impeding the flow of traffic at the time.
Okay. And for the defective tire?
Yes, sir. Yes, sir.
Is it? Okay, so at that point in time, he was coming toward you?
Yes.
Okay, so what's the next thing that happened?
I initiated a traffic stop.
Okay, did you pull out behind him, or did you get out and wave, or what did you do?
So as he approached me, I activated the lights on my patrol car. I exited out of the driver's seat, and I advised him to come over to my location.
Okay, all right, because he's on a moped and he can go right toward you?
Yes.
Okay. Now, the moped is what we would consider a standard moped, like a two-wheeled vehicle, correct?
Yes.
Propelled by a motor.
Yes.
Correct? Okay. Or self-propelled by a motor. Okay. All right. So you call Mr. Martin over. At that, let's say, prior to July 11, had you had any interaction with Mr. Martin?
I have had prior interaction with Mr. Martin.
Right. Did you recognize him that day?
As he started approaching closer to my patrol vehicle, I recognized him.
Okay. All right. So now you waved him over. He comes over to you. What's the next thing that happened?
He brings the moped over to my patrol vehicle as I exit. I told him to come on over. I asked him for his driver's license, at which point he told me that he did not need to provide one. I reiterated to him that he did need to provide a driver's license as he was driving a motor vehicle on the roadway. At that time, he produced me with a Michigan identification card.
Okay, so is a Michigan identification card something that's distinguishable from a driver's license?
Yes.
It's not a driver's license, correct?
Correct.
Okay. Did he indicate to you that he did not have a driver's license?
He made a comment stating that he did not have a driver's license.
Okay, so he hands you a Michigan ID card, correct?
Yes.
Okay, what is it that you do next at that time when he hands you that?
At that point, another coworker, Officer Anthony, arrived on scene. While he stood by with Mr. Martin, I went to my patrol vehicle. Using the in-car computer, I queried Mr. Martin's name information, which indicated that his driver's license was in fact revoked.
Officer Varg, I'm going to approach you with what's been marked as People's Exhibit Number 1. Just take a moment to look at that. Now, before I ask you about this, your testimony is that when you had looked up on your in-car computer, which is it linked to the Secretary of State?
Yes.
Okay. It had come up Eric Martin revoked, correct?
Yes, sir.
Okay. Now, I've handed you what's been marked as Plaintiffs or People's Exhibit Number 1. Can you take a look at that and tell me what this is?
It is Mr. Eric Martin's driving record.
Okay. Does it indicate anything with regard to the status of his driving record?
His status is currently revoked.
Okay. Now, it looks like that this is a certified driving record, electronically certified in compliance with 257.204A as of October 23rd, 2024. So this looks like it's his current driving record, correct?
Yes.
Okay. And in looking at the driving record, does it provide prior violations or sanctions?
Yes, it does.
Okay. And up at the top, it says revoked, correct, on the upper right?
Yes.
And then with regard to the violations, I see some regarding 2020 years, 2021 and 2022. Can you see where the sanctions are for the Secretary of State and what it indicates?
Yes, it indicates revoked.
Okay. So those would be years prior to your stop on July 11th, 2023, correct?
Yes.
So it indicates that his license was revoked before that time, and it was in fact revoked as of the day that you stopped him?
Yes.
And it appears that it's still revoked today, correct?
Correct.
Your Honor, the people have moved for admission of exhibit number 1.
Your Honor, after speaking with Mr. Martin, as his co-counsel as to rules of evidence, I would state that this is an exception to the hearsay rule, under 803.6, in MCL 257.204A, so we have no objection to start.
I would concur, I'll admit it as People's Exhibit 1 or A?
1, I think we marked it as 1.
People's Exhibit 1.
Thank you. Okay, after your encounter with Mr. Martin, or at least during, and after you ran his name in your computer and saw that he had a revoked license or didn't have a valid one at that time, what is the next thing that you did with respect to Mr. Martin? What did you do?
The next thing that I did was I placed Mr. Martin under arrest for driving on a revoked license. I placed him in handcuffs, placed him in the back of my patrol vehicle. At that time, I queried the registration on the moped in our in-car computer, which was registered to Mr. Martin. While querying that, it also indicated that there was no insurance on the moped. It would say EIVN, which is electronic insurance verification, and the N stands for no. At that time, I issued Mr. Martin a citation for driving on a revoked license, no proof of insurance, and a defective tire for the rear flat tire. I advised Mr. Martin that he could exit my patrol vehicle. I unhandcuffed him, issued him a citation, explained him how to take care of it, and advised him that his moped was to be towed by area towing.
And why did the moped need to be towed by area towing?
Well, I couldn't just leave it in the park. Mr. Martin did not have a valid driver's license to drive it away from the scene. It had a rear flat tire and no insurance on the moped, which you're required to have insurance on a motor vehicle.
And through the department, do we have an official policy on how to inventory property and things?
Yes.
So you're not authorized to throw it in your trunk and drive away?
Correct.
No, it needs to be properly accounted for, both for the evidence for the issue or even just the property, and also for the safety and or convenience of the parties that you may be inventorying something, correct?
Yes.
Okay. Based upon your observation and you running Mr. Martin's record, it did appear to be over the age of 19, correct?
Yes.
Born in 1973?
Yes.
And this stop, this brief investigation by you and the issuance of the citation all occurred within the city of Taylor, correct?
Yes, it did.
And you observed him operating the moped on the roadway, correct?
I did, yes.
I have no further questions, Your Honor. Thank you.
Cross-examination. Mr. Martin, will you be doing cross-examination or Mr.?
Yes, and in addition, Tim, anything additional he wants to add, of course.
Okay, so you're going to, and then anything he wants to, sure.
Yeah. Hey, Anthony Board, we have evidence that the so-called moped goes over 30 miles an hour. Are you aware of it?
I don't have evidence of that. No.
Okay, question number 2. Do you have evidence that the motor, the so-called motor, as you said, is in excess exceeding a 100 cc?
No.
Okay, now you said you recognize me. Where do you recognize me from?
Your address on Clifford Street?
Right. More specific, so to be more specific?
Your address, the 9,000 block of Clifford?
Right. But I mean, do you recognize me from filing a lot of complaints on you and your officers?
I don't.
And or your other officers, there's not.
I don't. I recognize you from the domestic violence disputes that we called to at your residence.
Are you aware that I filed many complaints on Taylor police officers, the Taylor Police Department?
I am not, that's not a part of my job description or duties to deal with complaints or to know about people who file complaints.
So you haven't heard it from a fellow police officer, he wrote complaints on us.
No, I have not.
Next question, I'm set things right now, but. So, you say when I was crossing North Line, my tire went flat and I stopped. And that's, wait, hold on, before we go there. You said I was impeding traffic, you made that statement. You elaborate more on it, how was I impeding traffic? Was that on, where was that at?
You're on Racco Road, sitting at the red light at North Line.
Right.
When the light had turned green, you were off of your moped, standing at the rear of your bike, looking at your tire while there's traffic behind you, impeding their flow of traveling when the light turned green.
And how long do you allege that this happened that I impeded traffic?
Approximately 3 to 5 seconds. I'm not exactly sure. It was a short period of time.
You said the light was green then? During this 3 to 5 seconds, or was it red or what?
When you first exited the moped, the light was red, but as you exited the moped, the light had turned green.
When the light turned green, did I hurry to take off, or was I still there, or what?
When the light turned green, you were standing in the middle of the roadway at the rear of your moped.
For how long?
Like I said, approximately 3 to 5 seconds.
Do you have any video evidence to support that?
I'm not 100% sure what my dash camera picked up at the time.
Okay, so now, you had the ticket for defective type. Can you elaborate more on that? What's the problem with it? Well, you said it's defective. What do you mean by defective tire?
The tire on the moped was flat. You were operating it on the roadway.
How long was I operating the road? Was it short term?
Prior to my contact with you, I'm unsure how long you were operating it on the roadway. But when I observed you, you were operating the moped with a flat tire on the roadway.
So the truth say it was short term then? You observed me? It was a flat tire, then I stopped, got off it, right?
Like I said, I observed you traveling northbound on Racco, approaching North Line, stop at the intersection, and then proceed through it, the Heritage Park entrance up.
Which is, how much longer after that? How many feet after the light or?
I'm not sure. I didn't measure it.
Well, let's say in general, looking, going off, I know Zach, you didn't have a tape ruler, but by your visual observation, how long was I traveling with this flat tire, what seemed to be, it seemed to be a flat tire. How long did you see me traveling from North Line? Is it true to say it was a short distance?
I'm unsure of the distance. I just observed you traveling on the road of Racco.
Well, let's take a guess. What would you say? It's
I don't feel
50 feet,
comfortable
100
making a
feet? 50 feet, 100 feet?
Like I said before, I don't feel comfortable guessing on how far I watched you travel on the way.
Well, then in that case, did you have any diagrams to show? Do you have any evidence to show from point A to point B where I suppose you traveled on this flat tire?
I do not have any diagrams. I just recall you traveling on Racco Road on the roadway operating the moped.
You can't say whether it's short term or long term, so you want to say that, right? Generally.
I can.
All right. Forgetting anything else here? Are you guys schooled on the right to travel law?
Could you repeat the question?
Are you guys schooled as a tailored police officer, you specifically? Have you been schooled on the right to travel by the U.S. Supreme Court? Like what the U.S. Supreme Court says on that law, have you guys been schooled on that at all?
Schooled?
Taught, yeah, what it teaches about people's right to travel. Instead of just these statutes that you guys are always going off of. You've been trained, use the word
He's
trained.
asking a fact witness about
Yeah,
something law with regard to the Supreme Court.
it's the same.
Okay, well, trained, I only use the word trained. That's okay when you train, have you been trained on the law of right to travel? Okay, that's not, I'm aware this is not.
It's not about that. You're asking somebody who is not a law professor or
No.
an attorney, whether or not, he's already answered your question. Have you been schooled or trained? And he's saying, no. they didn't have any
Factualized.
Special training. So
Right, okay, well, that's what I want you to do. What does your training consist of as to what the laws are?
There's a legal portion of the police academy and regular in-house police training provided by the police department.
As to one supposedly driving? Do they touch anything about the right to travel?
I know you need a driver's license to operate a motor vehicle on the roadway.
Right. What about? They haven't mentioned nothing to about the right to travel.
As I stated, I've been trained and taught in my academy and police training that you need a driver's license to operate a motor vehicle on the roadway.
That's all the questions right now. I reserve my right if I think of any more. That's it for now.
You had to throw that, I reserve my right in there.
Mr. Hadley, anything?
Good afternoon, Officer.
Good afternoon, sir.
Yeah, tell me, sir. I just have a couple quick questions. There's no trick questions today. You know the answers to everything I'm going to ask you, okay? You did create a police report after the stop of Mr. Martin, correct?
Yes, it is.
It's factually accurate. Your police report didn't have any photographs of the rear tire attached to it, correct?
Correct, it did not.
Okay. The day that you were out patrolling, did you have the body worn camera?
I did.
And was it active and working that day?
Yes, it was.
Okay. And as part of the preparation for this case, did you have an opportunity to go back over your body worn cam? I mean, to kind of remind yourself of what had happened that day?
I believe at some point during one of the court proceedings, I have.
Got a chance to go back and just kind of see what had happened that day?
Yes.
Okay. Your prior testimony was you were stationary, correct? And Mr. Martin was driving towards you?
Yes.
Okay. So you could, it sounds kind of obvious, but you couldn't see the back tire as he was driving towards you, correct?
The back tire
Yes, of the moped as he was driving towards you, because it was in the back.
Initially, no.
Okay. Mr. Martin didn't resist or physically prevent you from fulfilling your duties that day, did he?
He did not. At first, he did not want to provide me with his driver's license, but as I told him that he was required to by the state law, he then provided his identification card.
So now I am going to put the words in your mouth a little bit. So it'd be true to say the only evidence we have of the condition of Mr. Martin's tire that day, let me back up, strike that. Can we agree that the video of your body worn cam doesn't depict maybe a very crystal clear image of that rear tire?
I'm not sure. I didn't watch the body camera today before today's court hearing.
More than happy to. The stop itself is about 4 or 5 minutes. I don't really want to belabor the process, but if it'd be helpful, would you like to, again? Or how about we do this instead? Can you tell me where your body worn cam is positioned on your uniform as to like what it would typically record as your? Tell me when to stop as far as like. So if you and I are here,
my body camera's right here. My
left. Let the record reflect that the witness took a standing position at the witness chair. and he's touching the middle right side of his chest.
Would it be fair if we're standing close together that you would only see the upper half of my body? You might not see everything that's below.
I guess it just depends on how close we are while interacting with each other.
Mr. Hadley, I don't mean to interrupt, but when you step in between the podium and there, you go into a dead zone.
Can't hear me.
Yeah, it's true.
My apologies. Should have addressed that before I moved around the well.
I should have let everybody know about that, but please proceed.
Thank you, Your Honor. The officer, really don't have any further questions to go down this line. I just, so we're in clarification, there was no picture of the rear tire, correct?
Taken from me, no. I know when area towing takes possession of a vehicle, they do photograph the vehicle on the bed of their tow truck prior to leaving the scene.
So for today's purposes, the only evidence that's being admitted would be your testimony as to what the condition of the tire was, correct?
Correct.
Okay. I have no further questions for this witness, Your Honor.
That's no questions. Yeah.
Here he comes.
Why did you, what was the reason for you pulling me over, or making me come to you?
My initial reason was because you were impeding the flow of traffic at the intersection of North Line and Racco.
It wasn't for a flat tire. Next question. Now, did I provide you my ID by consent, or was it due to your threat of saying I must provide it?
I'm going to say it's objection. It calls for speculation. He doesn't know what you're thinking.
No, I'm asking him why. Okay, I'm asking him why did you make me give you my ID? Did you make me give you my ID?
Objection, Your Honor. Asked and answered. He's already testified about the interaction and how he ended up with Mr. Martin's ID.
Sustained.
No questions, all right?
Mr. Hadley, anything further from the side?
Absolutely not. We'd ask the court to excuse this witness if there's nothing for redirect.
Yeah. I have no further questions for this witness, Your Honor.
Mr. Martin, any witnesses?
Well, I did want to bring the witness and that you, besides the hearing officer issue, no, you're ruling on that.
Sir, the hearing officer from the city of Livonia who denied your license one time ago has no relevance to this case.
I don't want to explain why, but
It doesn't have any relevance to this case, and I can't bring in anything that's not relevant. Any further discussion is going to try to make possibly make a mistrial. I'll hold you in contempt of court. So say another word about it.
Oh, here comes the contempt.
You're gonna have to advising Mr. Martin of his Sixth Amendment rights, which I think he's now fully aware of. His knowing and voluntary decision that he would like to take the stand on his own behalf. At this time, Mr. Martin will be calling Mr. Martin at the stand. I will be asking a couple questions.
Okay, so just for the record, I'm not going to allow Mr. Martin to just testify in some sort of narrative form. He's going to be asked questions by you. Is that how it is?
Yes, sir.
Okay. And Mr. Martin, you understand that you are subject to any cross-examination by the prosecution if you take the stand. You understand that?
no, comprehend that.
All righty. And sir, you understand knowingly and voluntarily that you are choosing to take the stand, knowing that you have the right to remain silent, not have that silence used against you. You understand that?
Yes.
Okay. And counsel, as a co-counsel here, has explained all of that to you. Is that correct?
Yep.
All right. And Mr. Martin, you may take the stand, sir. I find that you're knowingly and voluntarily doing so.
Stand, sir. Madam Recorder, I'll stay put at the podium this time for us.
Mr. Martin, do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may be seated, sir. Please use a nice outside voice close to the microphone so that we can make sure that we make a good record that everybody can hear. All right?
All right. Please state your full name for the record.
Capital E, lowercase r-I-C, of the capital M, lowercase a-r-t-I-n family. Living private man, money sovereignty. as the US Supreme Court recognizes, not a corporation, legal fiction entity. It's being fraudulently acted on as if I am.
Where were you on July 11th of 2023 at approximately 4 p.m.?
Riding my, traveling by right on my moped, about to cross the street of North Line. And I do not remember, well, give my time, I might just stick strictly with your question. Elaborate more, just.
Let me prompt you to say, can you tell me a little further about what happened that day?
I was traveling by right on my moped without, I wasn't carrying passengers of property for hire at the time. So therefore it meets the definition of traveling by right. I do not remember stopping at getting off and impeding traffic. I do not remember myself doing that.
What do you, Mr. Martin, what do you recall the condition of your rear tire being that day?
My tire did go flat on me when I remember it when I crossed North Line Street. A short distance, the tire had just went flat, and I stopped the moped. It went flat. That's it. And this one, and it was a short distance. I'm thinking roughly 50 feet, maybe 100 feet. It wasn't long, but it's like any flat tire, you gotta stop so I don't damage my rim. But so I stopped, and but also during this is when Anthony Borg.
I'm going to ask you another follow-up question. So, why don't you tell us when you first recall seeing the officer?
Once I crossed the North Line, it was just a little bit past that. Anthony Borg was there. There's another one of his partners, and he called me over. He said, "Hey, come here." So when he said that, I figured I'm going to threaten to arrest to stop, because if I don't, he may try to arrest me or write some ticket like obstruction of justice or something. So under threatened arrest, not willingly, contractually, I stopped against my consent. And this is when the rest followed. As he said, he arrested me and he forced my identification from me, which again, I did not willingly do. I figured if I didn't give him my ID, it's going to be, a charge of obstructions. I've been seeing YouTube videos, people get charged by cops sometimes is they don't give their ID. They don't self-incriminate yourself, basically. They get charged with obstruction of justice. So under that threatened arrest, I gave my ID home.
Mr. Martin, let me ask a better question. Would you like to describe any of the characteristics of the device that you were on that day? You asked some questions previously about the vehicle. Is there anything that you think is relevant for us to know about this vehicle?
Well, the burden of proof is on the prosecutor. So I'm silent on that. Burden's on them.
Understood, Mr. Martin. Factually, is there anything that you would like the jury to know about the vehicle or the moped? It's your opportunity to sort of explain any of the facts that you.
No, except for I was traveling by right, regardless of what it is. It's not important, as I was shown by the law, whether it had an electric motor or a gasoline motor, whether it was called, I don't think I'm going to prove in my argument how it was irrelevant anyways. Like I said, the burden of proof is on the prosecutor, not me, so I remain silent on that issue.
Your Honor, as this is a little bit unusual way to have a direct examination, I would like to ask an open-ended question. I understand that we can't just go for a full narrative, but Mr. Martin.
And I object to that extra question too, because it would be self-incriminating, even if, hypothetically, if it wasn't.
Understood.
Right.
Okay, then that's why we're giving you an opportunity to clear that up right now. This is your chance, Mr. Martin. I don't have any more direct questions for you right now. Was there anything else that you would like to tell the jury at this time, factually, about what happened on July 11th of 2023 at approximately 4 p.m. thereafter, immediately after?
Well, yeah, also Anthony Borg had no legit reason for pulling me over. He seen me, he pulled me over. He was going, as his testimony said himself, he just noticed me from prior experience. Now, that is not a justified reason to pull me over. To just go by and say, okay, in fact, let's say a year or two ago, I didn't have a driver's license. That doesn't mean I don't have one now, so you can't just go pulling people over because you think, because a year or two ago, the guy didn't have a license, so let's just pull him over again, let's just see. So this is why it's harassment to me, factual wise, it supports that, and in my mind, that's what it is. And it's retaliation for my complaints.
Mr. Martin, before I ask opposing counsel if he has any questions for you, is there anything else you would like to tell us?
Nothing else right now.
Understood. I will have a chance when Mr. Greco's done to stand back up and do what's called redirect. So I will pass the witness at this time.
And that redirect will be only under the scope of cross-examination.
I'm sorry, and thank you for clarifying that.
All this.
Mr. Greco, cross-examination.
Mr. Martin, on the afternoon of July 11th, 2023, as you've testified, you were driving your moped on North Line Road near Heritage Park, correct?
No, not correct.
You didn't just testify about that?
Yeah, I didn't say I was driving. Did I use those words? No.
Were you traveling on your moped?
Traveling by road.
No, hang on a second. Were you traveling on your moped on July 11th around 4 o'clock on North Line Road?
I'll dispute that. Traveling by road.
Okay, thank you.
Same as driving.
Okay. When you were on the moped, right? This is not a Flintstones thing. You were like moving your feet. No, you just said it was a moped during your direct exam.
No.
It has a motor,
I did
correct?
not say that. No, I did not say that. I
You
said
keep referring.
I'm gonna clarify, in case you misheard me, I says regardless whether it is or not, I remain silent on that issue because it's for the prosecutor's burden to prove. I don't,
After you indicated it was a
motorcycle,
moped. It's
electric
okay.
bike.
And you were in the city of Taylor, correct?
Well, what's your definition of in the city of Taylor? Does that mean?
Okay,
subject to the corporation?
you can answer my question. Do you know if you were in the city of Taylor that day?
Yes, I was.
Okay, thank you.
All right, I just want to understand, that does not.
No, it's okay. I just answered so you would understand it. Okay, so that's clear. We're good. Okay, and you just testified that you admit that at or around the time that Officer Borg pulled you over, that your tire was in fact flat, right?
It just went flat, yes.
Okay, regardless of whether it's on his body cam, it was in fact flat, right? So we can establish that?
Yes.
Okay. And you admit that you didn't have a valid driver's license that day, correct?
Yeah, I admit that, I didn't have a driver's license.
Okay, that's fine. You acknowledge that state law requires you to have a driver's license. You just disagree that it should be applicable to you, correct?
No, it's not correct. As my opening statement says, I do not, no, the state law does not mandate me as a human, as I will show with my legal arguments,
I
to have a
understand.
driver's license.
No.
And you're traveling by right, which is a difference by the law.
I understand. Listen
Driving is
listen to my question again. You acknowledge that the state law says that it requires to operate a motor vehicle on the road, you need a driver's
It's
license,
a
right?
fraud. No, it requires, it says the Pacific statute uses the word person, and as I will demonstrate, the US Supreme Court said persons are defined as, it's distinguished from a sovereign, one of the sovereign people. There's a difference. So it's really a corporation, it's all a fraud. What's really being charged is a corporation, all capital letters, names, which is not me as a human.
Your testimony that you're not a person,
Is that I am a sovereign, one of the sovereign people, as the US Supreme Court said.
and
People are sovereign.
right, and your testimony is that because you're not a person, that you are not required under the laws of the state of Michigan to have a driver's license to operate a motor vehicle, correct?
That's right.
Okay, thank you. I have no further questions.
Any redirect under the small scope of the direct, cross-examination.
I'm pulling over to inspect whatever condition your rear tire was in. You were able to still drive it off? Or were you able to still drive it off?
It went down flat, but, it went flat. And I can't remember if it was, went all the way flat. Actually, I think it has had a little bit more on there, but I won't feel safe sitting on it, but I could have walked away with it. And in contrast to the testimony that, the police officer said, for example, it was abandoned, that was a lie. So that's something else I want to mention too. I did not abandon my vehicle. No time, it was private property. I did not abandon it. I could have walked away with it from the scene without traveling by right on it, or we want to call it driving. I didn't have to do none of that. So that's another reason why they didn't have to tow it. And regardless of the flat tire issue, I could have walked away with it anyways.
Mr. Martin, based on the questions that the prosecutor just asked you, I'm going to ask you an open-ended question because you're representing yourself today and I'm assisting you with the representation. Is there anything that you would like to state to the jury in response to the questions that Mr. Greco just asked, limited to that, nothing new, but limited to that area, as the judge is instructed?
Yeah, I'm gonna say to the jury as to what the prosecutor said.
Correct. It's an open-ended question to you to, again, as you're representing yourself in this, anything else that you'd like to state on this matter?
Besides what I get to say in the argument, I can't. Well, actually, I do have some questions for the prosecutor. I need to get. I have them written down. No, I don't know if these can be considered within the realm of direct examination. Do I have questions for the prosecutor? This has to do with a legal argument. Another one to dismiss this case, which has to do with your standing, Greco. Now, for example, one of them is.
Mr. Martin, I've already made a ruling on your motion to dismiss based on lack of standing, and I explained to you
This is totally
that I
different.
have jurisdiction and that the prosecution and the city of Taylor have standing.
This is a different argument based on standing. It's different.
Different argument based on standing.
No, but it's different.
Well, first off, if you're gonna make any sort of testimony while you're sitting there as a witness, it's gonna be about facts. If you have any legal argument that you wanna make, you can do that after your closing argument. After the prosecution closes their argument, you can ask that the jury be excused. You can make any motion that you want to at that time. I'll make that ruling, and then we can go back on the record with the jury. But sitting in the witness chair is not the time when you make a motion, when you're not going to be asking questions of the prosecutor because he's not one of the people who you get to call as a witness.
So the questions I have to ask them are relevant to a defense I have to raise. Some people don't have to raise it now.
Like I said, we'll do that outside of the presence of the jury because I'm not going to have the jury tainted by any sort of bias things you're going to be bringing up that are either frivolous or have nothing to do with the Constitution.
So let me ask a better question, perhaps, Your Honor. Mr. Martin, are there any other facts that you would like to tell the jury related to the questions that you just answered for the prosecutor?
Can't think of any. I reserve my right if I remember it later. I can't think of any right now.
No problem. Just want to make sure that there wasn't anything we were leaving out. Your Honor, I have no further questions for Mr. Martin or any other direct at this time.
Sure. Mr. Greco, any further cross?
Nothing, Your Honor.
Hi, Mr. Martin, you may step down. And Mr. Martin, do you have any other witnesses to call?
Yes, like I said, I'd like to question Greco here. Yeah, he's one of my witnesses for one of some of the relevant defenses motions.
And you can't you can't call.
Right. Others are president, whatever.
You can't call opposing counsel as a witness. So.
But I think that is my due process.
It's not any of your due process whatsoever. So, do you have any other witnesses?
Oh, no. Let's rest our case.
Let's rest our case. Closing arguments. Mr. Greco?
Yes, Your Honor, very briefly, I'd like the jury to just a second, whether he is a person or a human being. I believe that the evidence showed that Eric Martin was traveling on a motor vehicle, a moped, in the city of Taylor on the late afternoon of July 11th, 2023, without a valid driver's license. In fact, the record here that you're going to be able to inspect is one. People's Exhibit number 1 shows that it was revoked. It says revoked at the top. You see the sanctions here from prior years, 2021, 2022, which pre-exist and predate the 2023. That it was in fact revoked. Regardless of this, he has admitted to you during his testimony that he did not have a valid license. He's admitted to you that the state of Michigan requires that persons are supposed to have a valid driver's license to drive on the road. He don't think that that applies to him. Once you hear the jury instructions, which he's already read to you, you're going to find the defendant guilty, and you should find the defendant guilty. There's no more case clearer than this. Thank you for your time. Do appreciate it.
And Mr. Martin, your closing argument?
Yes. I have a lot, so let's see, start with. All right, and now she's showing this law to the jury here. So
First off, you're not gonna show any law to the jury.
So I'm not allowed to show how I'm not
Listen,
guilty.
sir, listen, I'm gonna tell you, because I've told you 5 times, when it comes to the jury, their duty is to hear the facts. And it's my duty to instruct them on what the law is. I have right here. Sir, I teach constitutional law for 20 years. I know exactly what I'm talking about. So it is my duty to instruct them on what the law in this case is. And the law in this case is there are certain elements, 3 elements. 1, that the individual was traveling or operating a motor vehicle. 2, on a public road or access road. And 3, they didn't have a license at the time, or their license was either suspended, revoked, or denied. Those are the 3 elements. Those are the law that that's the law that I'm gonna explain to them. Any other law that you are trying to show is not for the jury, not to hear from you, because you're not the one who has the duty to explain it to the jury. Okay? So if you think that you have a motion to dismiss, then this case would have already been dismissed. If your law that you wanted to point to was applicable, it would have already dismissed this case and we wouldn't even be in the jury trial. So if you want to make any sort of motions outside of the jury based on the law that you have in your hand, you're welcome to do so. I'll entertain said motion. But you're not going to be instructing the jury on this law here. Closing arguments is so that you can recap the facts and put your version of the facts on display at closing arguments. So if you'd like to do your closing argument, go ahead.
Well, this is part of my closing, so if I enter this as admission, my legal arguments as exhibits, then don't I have the right to show them the law that supports that I am not guilty?
Sir, you have to follow the rules of evidence just like any other litigant has to. And all I'm required to do is make sure that you have every opportunity to put on a fair trial. You had the opportunity to be cross-examined, you had the opportunity to remain silent, you chose to testify. Your own co-counsel asked you a series of questions. He even asked you a very open-ended question. Is there any other fact that you want the jury to know about the date and time of the incident in particular? And you said, no, nothing at this time. So you had every opportunity to show any other facts that you wanted to.
So I'm okay then if you're
just saying this is the time. This is the time for your closing argument. This is where you recap the facts that were put into evidence. This is where you say things like, as the evidence showed, and then you say what your theory of the case is. This is not a legal argument. This is not a dissertation on legal philosophy. If you want to make that kind of motion, I'll do that outside of the presence of the jury so as to not taint the jury. You're literally tainting the jury right now just by attempting to do so. And if you continue, I'm gonna.
Maybe very briefly, Your Honor, I know we're to the end. This is going to change that. Your Honor, after having the opportunity to consult with Mr. Martin, explain to him what a motion for directed verdict would entail, Mr. Martin would like to address this court with a motion at this time.
I'm going to ask the jury to stand up. All rise. I'm going to ask the jury to follow Officer Rose into the hallway and have a seat in the benches out there so we can come back. All right, so the jury is out of the presence and the prosecution has rested. Are there any motions?
Your Honor, just going to make a record real quick. So Mr. Martin has been advised by co-counsel that legal precedent is not going to be put forth through direct or cross-exam testimony, that this is the proper avenue and the proper time to make his legal arguments. And so he understands that, again, I shouldn't say what he understands. I've advised him that that's what this motion is for. This is the proper venue, and that's where we're at. Mr. Martin, you'd like to make your argument?
Mr. Martin, you're making a motion for a directed verdict, is that correct?
Yep.
Okay.
Mr. Martin, I've advised him that his burden starts with people have not, or his argument starts with the people have not met their burden, and he's now to explain to the court what legal authority he has that supports that based on what we've heard today.
Very good. Mr. Martin, a very, very sound foundation has been laid for you by co-counsel. Please proceed.
As the testimony, the board admitted he did not know whether what I was traveling went 30 miles an hour or not, up to 30 miles an hour or more, and does not exceed 100 cc. He admitted that he did not know that. That is both of them elements. Actually, only takes one of the elements, but he admitted to both of them elements. He didn't know whether they exist. Both of them elements are necessary to exist to meet the definition of a moped under MCL 257.32b, which makes it clear that is the definition of a moped. One, it must go at least 30 miles an hour. Two, does not exceed 100 cc. He doesn't know, as he admitted, don't have evidence. So there's no evidence that it wasn't even a moped. Therefore, the charge must be dismissed on that alone. And I have more.
All right, so let's do this for the sake of appellate representation and argumentation. You say you have more. So let me make rulings as to each of those so that the appellate court can take one, do what they want. Because, like, for example, if they overturn me on that first one, there's no point to go and do anything with the rest. So with regard to the fact that you say that this case should be dismissed because the evidence did not show that it was a moped. The evidence clearly showed that it was a moped because, one, Officer Borg said he was driving a moped. Officer Borg is a person who I think I don't know any person who couldn't recognize a moped. Now you're talking about what is the legal definition of a moped that you can find in some statute. Sure, I get that. Whatever. Well, there's some statute that says things that just if you can do 30 miles an hour and you have this many cc's or whatever, we'll call it a moped. But I also just need testimony. All I need is testimony from a competent individual who has knowledge of the same, of what a moped is. He was asked, did you recognize? Yeah, it's just a common moped, as you would commonly know or refer to as a moped. So for that reason, that specific motion to dismiss, a motion for directed verdict is denied. On to your next one.
I'd like to say some response, but I don't know.
And you'll have that opportunity to do so on appeal, sir.
All right, well, next.
Your Honor, if I may just address it briefly.
I'm sorry.
Was it all right?
I ruled that.
Okay, fine.
It was clear testimony by Officer Borg.
Yeah.
And he recognized it as a moped.
And the statute requires that he's operating a motor vehicle. The definition for a moped only applies to whether or not you could get a restricted license.
Sure.
But
And he's
vehicle,
clearly not 15 to 19 years old, so it doesn't matter.
It was every vehicle that's
It was a motor vehicle,
self-propelled.
absolutely. And there was testimony that it was on the road. Doesn't matter how short or how long it does. It's for any brief time at all. If you're operating it operating it on a roadway, it doesn't matter if it's for a millisecond. And so for that reason, as far as a moped goes, a moped is clearly. You said you drove it off, like you said it in your opening statement. You said it when you were testifying. So it definitely wasn't a wooden, like one of those rocking horses or something like that. It was something that actually moves when you make it try to move and you push buttons or do something and it goes. So it was obviously a motor vehicle because you weren't pedaling it, you weren't Flintstoning it, and you weren't rocking. So it was motorized. And it was on the road. So your motion for directed verdict with regard to the definition that you're trying to come up with about a moped is denied. Your next reason for directed verdict, sir, is?
People have not met their burden because, as the U.S. Supreme Court said in Packer versus Banton, page 259, 44 Supreme Court Reporter, page 259. I have copies here to give I'll get one of these prosecutor. The Supreme Court, their quote, you can tell it's right out of the law, but nothing I typed up on that. All right, the streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislature deems proper. So, as they're saying, the legislature can regulate the use of the roads when it's being used for profit. As Borg admitted, he had no evidence that I was carrying passenger property for profit. And as the Supreme Court case right here demonstrates, I have the right to use the roads, as long as it's not for profit. Since I wasn't doing it, I was not driving a motor vehicle. And also, I'm not done with that argument, so as an extension of part of that argument. All right, now the state statutes mention driving without a motor vehicle, use them terms, which is not a current. They don't give a real definition. Why on the people? I know we're doing that 20 years. I don't know everything, but okay, where is it at? I got it over there. Let me get it to you. Okay, point, and I got copies here so you can see this right off the law book of East Laban and prosecutor. Okay, it's 18 USC section 31, subsection 6 and 10.
First off, let me make a ruling on your Packard versus Batten motion. So you, under Packard versus Batten, they make a quote and there's a citation to it. It's cited in amongst other cases as well. State versus Johnson, 243 P 1073. There's Cummings versus Holmes at 155 P 171. Packard versus Batten at 44 Supreme Court 256. There's Hadfield versus London at 98 Washington 516. All of them quote to the same quote that originally comes from Hillhouse versus the United States, that says a citizen has a right to travel upon the public highways and to transport his property thereon. It doesn't say you can do it without a license. It just says that you have a right to travel, yes. But it doesn't mean, just because you have a right to travel doesn't mean that there is not a state's right under the health, safety, and welfare regulations to regulate those industries that have dangerous things. You can't drive a helicopter around. You can't drive a spaceship around. You can't, even a boat. Anything that could possibly run somebody over or kill somebody, you need to have a license. So you keep saying it. And all these people on the internet like to keep quoting to it. And it's not what it means. Read the whole case. Yes, you can have a right to travel, but the state has a right to license you. So for that reason, the Bantam, sir, don't approach my bench. Don't ever approach my bench.
Excuse me, well, thought I could do it.
Listen, trust me, you can give it to me all you want. I've read this matter 100 times. I've read every single one of those cases that I just quoted to you. Why? Because I'm fascinated by it. I too am a pure constitutionalist, and I almost want you to be right, but you're not. You can't just travel any way you want to. You can't do it in vehicles on public roads without a license. So for that, your Packard versus Banton, that's a misstatement of what the actual state of the law is. And yes, you do need a license. The Supreme Court of the United States has never said that you don't need a license. That federal statute has nothing to do with you driving on a road here in Michigan.
When I approach the bench, I show you this, so you can see word for word, they say what I just said about.
I want to hand it to Mr. Legislator. Mr. Hadley can give it to you.
The legislature only regulates it when it's being used for profit. They said that word for nothing. They didn't say nothing about only on.
Yes, I've read this in Packard. So the streets belong to the public and are primarily for the use of the public's ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislature deems proper. You're literally proving my point. It literally says may be prohibited or conditioned as the legislature
when it's being used for gain.
No, as it means, it doesn't say that. It doesn't do it at all under the 14th Amendment. Mr. Hadley, I'm going to give you this.
Thank you, Your Honor.
That's why I read it into the record, because you're literally proving my point for me, sir.
Mr. Martin, your motion has been heard. The judge has made a legal finding on this.
Yep.
The court reporter.
Let's move on. Let's move on to the next one. Your USC.
18 USC, federal statute made by Congress defines a motor vehicle different than the state.
Hold on. This is my court recorder.
I have the copy too. I can give it to you.
My court recorder is making a recording. I want to make sure that, because you start to speak a little, you get a little excited, and you start to mumble and speak fast. I want to make sure that everybody can hear you and that she can make a proper record. So you were about to tell me that 18 USC, what was the next part of the
section? 18 USC section 31, subsection 6 and 10. Both of those define a motor vehicle as one only being used to carry passengers or property, which the evidence shows, and as he admitted, I was not doing. He doesn't have no evidence to say I was doing. Therefore, I wasn't driving motor vehicle. Now, under Article 6 of the U.S. Constitution.
Can you see again, you're mumbling.
Okay, well, I'm just
So motor vehicle, the term motor vehicle, because I'll read it right. I'll read
yeah,
it.
go ahead, read the term motor vehicle.
So it says motor vehicle. The term motor vehicle, this is literally ready. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on highways in the transportation of passengers and property, or property and cargo. Okay? So
Now, I'm gonna cut you off on add on.
sure.
Okay.
Now let's go down to
six.
let's go down to paragraph 10
Right.
and get the definition of used for commercial purposes. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly and indirectly in connection with any business or other undertaking intended for profit. But you're talking about this section 31, and what is the whole section 31 about?
Now, well,
Exactly.
you just said it's about the definition of motor vehicle. Now, Article 6 of the Constitution, I'll point out, makes this, because Article 6 makes it clear, laws of the United States, which means federal statutes such as this, along with treaties and the U.S. Constitution, is supreme law of the land. So this definition is supreme over the state law definition, which doesn't say this. This is why I'm not guilty, because I wasn't driving a motor vehicle.
May I address that, Your Honor?
Please.
Yeah, so there is nothing that I'm aware of in the United States that I'm at least aware of that citizens of the United States or natural people or human beings can obtain a federal driver's license. The regulation of roads and driver's licenses has been left to the states with respect to the issuance of licenses and motor vehicle codes to be enforced locally and in the states. There are going to be a number of definitions for the word person, for the word corporation, for the word motor vehicle as it's applicable to any particular statute. And if you pick a federal statute that is applicable to motor carriers and it's defining motor vehicles and what's subject to those regulations, then that may be the definition. However, federal law only preempts local and state law where it takes up the space. And the federal government has not taken up a space with the issuance of driver's licenses to the citizens of the particular states. That's why you have different rules. Some you can get a permit at 15, some at 16. Sometimes you get a restricted license, sometimes all those things. It's different in every state. That's why.
Mr. Martin.
Object against
Mr. Martin.
Article 6.
Mr. Martin.
Is supreme law.
Mr. Martin. Everything that Mr. Greco just stated is correct, and it's the reason why I'm denying your motion. Additionally, what you need to do is you need to go to section, you need to go to 18 USC, go to chapter 2 before you get to section 31. Because what it says, and actually what you need to do is you can actually go right to part 1, because let me give you the total things so you can read the full statutory history. It's 18 USC. So that's Title 18, Part 1. Part 1 is all the crimes. These are all federal crimes. Every federal crime that you can think of, you can find in Section 18. So now we go to Chapter 2. Chapter 2 is aircrafts and motor vehicles. So every crime that you could possibly commit using an aircraft or a motor vehicle, a federal crime, is found in 18 USC Chapter 1, Part 2, and then you go to these sections. The first section is 31, and that's where you find your definition. So for everything we're about to say, for every crime we're about to talk about, here's the definition of an aircraft, here's the definition of a vehicle. And so you're going to find things like fraud involving aircrafts, violence against international airports, drive-by shootings. These are all things that the federal government has made a crime about, and they're defining just for those statutes that thing. The problem is, everybody on the internet who wants to be like, I got a right to travel, look at this, look what I found this
let's take this one statute out of context and just stand on it like it's Plymouth Rock. No, that's the definition for all the crimes that are underneath it. 31, section 31 is just a defining statute that defines all the terms that you're going to find in 31, 32, 33, and all the way down of all the crimes that federally they have, commercial vehicles that are required to stop for inspections, unsafe operation of an unmanned aircraft, aiming a laser pointer at an aircraft, all these different things that are crimes under federal law. That section 31 is only the definition for those, nothing else. It's not superseding state law. Why? Because under the 10th Amendment, anything that's not stated specifically in the Constitution reverts back to the states and its peoples. And Congress has made, like Mr. Greco said, has made no effort to say, look, we're going to create a national driver's license so you can just come and go anywhere you want. You know, you want to know why they didn't make a national driver's license?
I think
because of Article 4, the privileges and immunities. When I go to Ohio, they can't arrest me for not having a license because I have a Michigan license. And when Ohio people come up here, we can't arrest them because they don't have a Michigan driver's license. Under the privileges and immunities, there's already a constitutional provision that allows for licensing, whether it's your license to carry a firearm, or whether it's your concealed weapons permit, or whether it's your, like hunting licenses and things like that. Sure, you got to go right to those states. Why? Because that's their state. They still have sovereign powers. They still have their own constitutions. So your definition from 18 USC section 31, you're skipping the two parts that are in between that. And those two parts that are in between that are part 1, chapter 2, which tells you exactly what 31 is doing. Okay. So for that reason, it's denied. You can take it up on appeal if you'd like. Your next reason for directed verdict?
Yes, no, this is another case, Pickerton versus Berger, Michigan Supreme Court, decided in 1889. And I have the pages here to give to you, so you can show the pages.
I don't need you to give me any copies of anything, sir.
584, quote unquote, they say, personal, this is the ball on the right to travel, personal liberty, which is guaranteed to every citizen under our Constitution and laws, consists of the right of locomotion, right, not privilege, okay, to go where one pleases and when.
Sure, and you just can't do it by car, denied.
They never said it, so.
You just can't do it by car.
They did not say that.
You can walk yourself anywhere you want to, when and how you want to do it. You can
Never
walk
they said
backwards,
to walk.
you can skip, you can do somersaults, you can cartwheel.
Yeah,
You can't use a car.
You can use a
That
car,
one's
motorcycle. They're saying
That was
that.
denied. Sir, you're not going to get argumentative with me. I've already told you that that's denied. There's no, that's not a legal argument. I admitted it. Yes, you have a right to travel. You can't do it by unlicensed driving of a vehicle.
Well, can I finish reading the Michigan Supreme Court code then?
No.
Like halfway through.
Because that one's denied. Already denied the
Looks like
same.
I got other cases based on the same laws.
And it's going to be repetitive evidence, and you're not gonna just keep coming up with a different case that says the same thing, that says you have a right to travel, because I admit, yes, you have a right to travel. You just can't do it by any sort of mechanical means that they need to license, whether it's by boat, or automobile, or helicopter, or spacecraft, or whatever the Jetsons thing would be. Any of those things, I'm sure you're going to need a regulation. Why? Because those things can kill people if they don't do it right. Walking, I don't know of anybody who's walked into somebody else and they ended up dying because they collided. So pretty safe with that. Riding a bike, yeah, same thing. So those methods, sure.
That's correct.
Doesn't matter.
Right, so it's about people's burdens. I think again, if you've got something that is a new argument about what they didn't do, if it's not, you've already made your appellate record. We've got a jury, and then if you do that.
Oh, I do want to, since you've been not going. So also, based on, I want to make another motion now to based on you denying all my motions in violation of my constitutional rights.
That's incorrect, sir.
Well, this is, okay, I'm just stating my case anyways.
I'm merely making rulings based on the law. And so I'm not violating your constitutional right. Just because you don't get your way doesn't mean that you get your violation. This isn't kindergarten. This isn't kindergarten court. That's not how that works. We're not going to do temper tantrums with legal frivolous things and stomp our legal feet with a bunch of arguments that have no relevance nor substance at all. And then you just keep making it and making it and keep making it over and over until I get browbeaten enough to go, oh, you know what, Mr. Martin, I'm just going to dismiss the case. How about that? No, that's not going to happen. It has to be something. If you had something that was relevant, substantive, and right on point, I'd dismiss your case in a heartbeat because I've done it before with other cases. But you're not just going to keep bringing up the same, this case says I have a right to travel. True, it does. This case has a right to travel. Sure, it does. But that doesn't mean you can do it by not having a driver's license and operating any kind of motor vehicle. So do you have any other, do you have anything?
Different arguments here. Or
Do you have any different argument that's not, I have a right to travel?
Yeah, this one, okay, based, I'm going to dismiss this case based on Declaration of Independence of 1776.
You already did that. That was the second motion you made when you first started making motions. Next.
Well,
I think you may have reshuffled your paperwork, so.
yeah.
Going back up to the top.
I'm gonna move that you be disqualified from the case for denying my motions. I'm alleging that it was done in violation of the Constitution. Therefore, you should be recused from the case and dismissed.
Okay. Pursuant to Michigan Code Rule 2.003, any motions, I think it's C, any motions to disqualify are heard by the judge who's presiding, which is me, and I'm denying that motion.
Therefore,
That might be
request that you send it.
citation, but I think
I request that you send this motion that you're denying to dismiss yourself to the state court administrator, which is supposed to be done by the court rules.
I did.
Have the state court administrator deal with the matter.
MCR 2.003, I'm thinking this is for disqualification, and it's heard by the judge that's presiding it, and I am denying that motion. You can take that up on appeal as well.
I believe that's all the legal arguments I have.
All right, so
I think it's almost I said before the paper.
Your Honor, on the civil infraction, yeah, I was gonna say real quick before I pull them on the civil infraction, I can keep it, I can do it.
Let's just do the civil infractions right now while they're already out,
Yeah.
so yeah.
So I think the testimony clearly established that he was operating with no proof of insurance. In fact, he had no insurance. So the evidence of that. With regard to the flat tire, it looks like he did have a flat tire. With regard to the
Said it in his opening statement. He even said to the jury, "Come on, really? If you're not picking on me, why are you coming at me about a flat tire?"
And he testified toward the end that he did not think during his sworn testimony, he indicated that he did not think he was operable toward the end because it was flat.
Yeah. So, and the report, when he ran the report on the computer, it came up that there's no insurance. So, anything you want to say about that no insurance or the?
Yeah, I'm still looking for the MCL right now. MCL
on the
clearly
insurance?
makes it clear that.
Sir, if you take one more step, I swear I'll come over this bench.
Yeah, okay, so, no insurance is required for the MCL I'm looking at right now, for a moped specifically, it is not required of a.
No, there isn't at all. But once you drive a motor vehicle, once you take it onto the road, because I also teach no-fault law at the law school. So once you take any motor vehicle onto the road, it has to be compliant with everything else is on the road. So that means you have to have insurance.
MCL.
The reason, and I can tell you the great case. The best case about it is a kid who's driving his moped on the road and he gets hit, and then his mom makes a claim with the insurance company and he gets denied. You want to know why? Because he's an uninsured motor vehiclist. As soon as he takes that moped on the road, boom. Same thing with people who take golf carts on the road. Boom. You better have insurance on your golf cart, because if you don't have insurance, like an actual, like the State Farm type motor insurance, as soon as it goes on the road, you're operating a vehicle with no insurance on the road. So
I have nothing further.
Yeah, so that's the MCL right here, clearly says.
Sir, you can take me up on appeal, but I just gave you my ruling of why that does not apply.
Your Honor, if I may, on the other civil infraction, I'm going to make a straight preponderance argument. I would state I understand that there was.
I'm going to dismiss the tire one because I don't know what the tire looked like, and I don't know what the tire. Because if the tire can move, then is it defective? If it can if I can drive on it.
That's my argument.
If I can drive on it, it's obviously not defective because defective means it doesn't work. If I go to use my washing machine and I put clothes in it, and all of a sudden I push the button and all I hear is nothing moving. Well, that's a defective washing machine. But if it washes my clothes, how defective is it? Even if it doesn't, like in a poor manner. So maybe it's a poor manner type of tire, but is it a defective tire? A defective tire won't roll. So
that's our argument.
Dismissed.
Thank you.
So it's responsible on the no proof, dismissed on the tire.
And let's get Mr. Martin, let's get the jury back in here again.
So I do find you responsible on the no proof of insurance. That's $165 in fines and costs. I'm dismissing your defective tire citation.
Your Honor, Officer Borg, I think we're done with the testimony and everything, so Officer Borg does have to leave.
Officer Borg is free to leave if he'd like to leave, yes.
Thank you, Your Honor. Thanks for your time.
Have a good day. All right, so Mr. Martin, your closing argument.
It took a lot of paperwork to find it. Okay, so one, this court doesn't have, the so-called court doesn't have jurisdiction for this matter because Article 3, Section 2 of the U.S. Constitution.
Mr. Martin, I've already made a ruling on that. If you're going to give your closing argument as to the facts that were presented, please do that. If you're going to give some sort of legal argument that you've already given before, and I've already made a ruling on, that's not.
I understand. How am I going to make a closing argument? I can't cite the law. The closing argument deals with.
The closing argument is about the facts that you presented. You presented facts. You got on the witness stand to talk about your facts, not any sort of legal arguments that have already been ruled on by me.
I don't understand.
You're more than welcome to have Mr. Hadley do your closing argument if you'd like.
I understand that defendant law 20 years is allowed to make.
My understanding is that closing arguments are about the facts that were presented at trial, and you can talk about the facts that were presented at the trial and how that plays into your theory of the case. If you want to make motions to dismiss and things like that, which you've already made and denied, you're not going to just rehash those in front of the jury because that's not.
I'm not making motions. I'm making a legal argument.
You're not. It's not a legal argument. You know what, sir? Sit down. Mr. Hadley, you're going to do closing argument.
Ladies and gentlemen of the jury, thank you very much for your patience today. TV trials, it's a lot more exciting. There's not this weird stop starts. So thank you, sincerely. I know this has been an afternoon. Quite simply put, the people bear the burden of proof. You heard evidence today, and as the judge will instruct you, and it has instructed you, this is solely the people's burden. They must prove to you beyond a reasonable doubt, based on the actual evidence that's placed on the record today, that this individual violated the statute driving on a license revoked. Now, we can recap what we've heard today. We heard from the officer who testified more or less to his recollection of what happened. You can all make arguments that memories aren't perfect. You can speculate as to what actually happened that day. I mean, we do have this, the officer's testimony. He testified as to his recollection of what happened. You heard from Mr. Martin. We had our two witnesses today. He told you what had happened. Now, you heard no evidence that Mr. Martin injured, hurt anyone, ran a red light, speeded anything. It was, as he had stated on the stand, a victimless type of crime. So while Mr. Martin has, again, made some very interesting legal arguments to you today, what we really need to look at is, again, did the people meet their burden of proof? You know, was there enough evidence put before you today for you to make that decision? As co-counsel, the defendant, my position to you today is they haven't. It's a very high burden that they must hit. They have not hit that based on what they presented. So we'd ask that you return a guilty or a not guilty verdict based on what you've actually seen today. So I really, again, sincerely thank you for keeping an open mind as you go through this. Really, at the end of the day, I know that this is an individual who believes dearly in the arguments that he has made and the statements and the position that he's taken. And with that being said, this is a slate that people have. I have nothing further. Just thank you for your time.
Mr. Greco.
Yeah, just briefly, I think the testimony of both Officer Ward and the defendant, Mr. Martin, we have met the verdict, they violated the law that day. I'm not going to go through it again. We could use the officer's testimony or Mr. Martin's own admissions and testimony regarding what happened that day and how he violated the law. He just disagrees with it, but as the jury, you need to apply the law to the facts as the judge is instructed. Thank you.
This is the case of 231510, People versus Eric Martin. The jury has deliberated and is now back. Is there a foreman?
Sir.
All right. Mr. Foreman, has the jury reached a verdict?
Yes, sir.
In the case of the people of the city of Taylor versus Eric Martin on the charge of driving on a suspended revoked license, how does the jury find?
We found the defendant guilty, sir.
All right. And juror number one, juror number one, is that your verdict?
Yes.
Juror number two, is that your verdict?
Yes.
Juror number three was dismissed. Juror number four, was that your verdict?
Yes.
Juror number five, was that your verdict?
Yes, sir.
Juror number six, was that your verdict?
Yes.
Juror number seven, was that your verdict?
Yes.
Let the record reflect, if you're polling the jurors individually, that each of them has come to the same unanimous decision of guilty as to the driving on a revoked license. I'd like to thank and dismiss the jurors. All rise. Let the record also reflect that I'm going to place exhibit 1, plaintiff's people's 1, into the court file. Now we're going to set this for a sentencing date with a PSI, or we're moving for immediate sentencing today.
PSS. Gives the judge a sense. Judge, any sense of violation of the slavery or slavery. All this violation of the slavery. I agree to no sense. That's not the question.
All right, so I'll set it for a sentencing date then. And I'm going to refer to a pre-sentence investigation report. And you'll be notified by the probation department, sir, to come in for the pre-sentence investigation report. And then you'll be able to read the report before the day of sentencing. You'll be able to go over that with Mr. Hadley. And we'll see everybody at that time.
I'm going to stay it based on appealing the issue. Are we appealing it?
I can't give you any legal advice, sir.
Well, that's what it was. I'm going to stay it.
Sure.
Oh, stay the same.
All right.
I just did. It's an oral motion. I request to be appointed appointment of counsel Slavin to appeal these issues. Well, everything's been denied in this court. Is the record still on?
No, we're off the record.
Okay, let's go back on the record.
You're going to get a PSI.
All right,
The case isn't done
I want to
yet.
be appointed upon
The
counsel to
case,
appeal the issues.
there's no appeal yet because the case isn't done yet. You haven't been
No, I thought we were
sentenced.
appealing the issues that.
Well, you haven't been sentenced yet. Then after the sentencing, then the case is done, then you go to appeal.
I still have a right to interlocutory appeal the denials of my constitutional rights and my motions.
I can't give you any legal advice, sir. All I'm telling you is that you better show up for the PSI and for the sentencing date. Then you can do whatever you want on appeal. All right, this concludes this matter.